Welcome back. It's Friday Night Live. I'm Emily Baker. We have things to discuss. A lot has happened this week. And before we get into it, I saw all of the text crew's blue hearts in the chat, and y'all almost made me cry. Um, and I'm gonna touch on this now so we can touch on it early, and then I'm gonna move quickly on because I have all of the emotions, and we're gonna move into talking about law stuff and not get sidetracked in all of the emotions. But friend of mine and friend of the channel, Peter Mon, was in a very serious car accident a few days back, is in the hospital, and I am heartbroken about it. I am I just am. I am worried for my friend. The circumstances are just heartbreaking for everyone involved. Car accidents are so scary, and it also it's hard on a friend level because I'm scared for him. It's hard on a content creator level because I love him and I miss him. Like, it's an absence in my life because he posts so much, and so it's like a friendship that's an absence, but a content creator that I also love that's an absence. And so if you are inclined to send love, send light, send prayers, send thoughts, all of it, just send them to Peter and to his family and to everyone involved. I spent a lot of time working vehicular, so it's always hard for me. Um, I'm always just so heartbroken. So it was a very, very serious car accident. So everyone involved, sending prayers and love and light. So with that, I know it's hard to not speculate. But until his family releases a statement, that's all I'm going to say on that. I am sure his husband at some point will update and share what is going on directly. And once that happens, I will share that on my socials as well. I know it is a thought to all. It is just, I've been off of social a lot this week. And I shared that with you guys on Tuesday that I just needed a little bit of time and space because stuff I had going on in my family. So, in my extended family, my immediate family, good, but my extended family, we've had a lot going on. And so when I went onto social today, I was just hit. It feels like you get hit in the gut when you see someone that you care about, whether you know them directly or not, someone that you care about, um, that's been impacted so significantly. And all of those involved car accidents um, are so scary. So with that, the only thing I would remind the law nerds is that his family will need space. Everyone involved will need space and time. And when they comment, I will share that. So when we have a public statement, if we have a public statement from Alex or from Mel or from Tanya or any of his immediate family directly, then I will share that along with you. But until then, I'm not going to pontificate, speculate. It's not for that, and it's just too serious and too heavy. So I'm going to focus on sending my thoughts, prayers, and well wishes to everyone involved, and that's and not going any further with that. And again, I'm heartbroken. So thank you, law nerds, for just understanding that that's how I really approach things when we don't have information and we don't have direct information. I um I wait, and it's really hard, especially when you want to know. It is really hard to wait until you have more information, until you have more facts. It's one of the reasons I tend to cover lawsuits once they're filed, even though lawsuits are full of allegations and shade. When they are filed, it is someone's facts and it is someone's version of what happened. And so when things are new and happening and we don't have a lot of information, it is very hard to wait until we have more information. It is deeply uncomfortable. We want to know. I find that a lot of us take comfort in knowing things and wanting to know things. And so it is very, very hard to wait until we have more. But that is where I am. And I know how uncomfortable it is. So it is uncomfortable to wait and it is uncomfortable not to know. And it is something that know that I will continue spending my life working on is waiting until we know, because we're humans and we care, and we also answers make us feel better. And right now we're not going to feel better. It's going to be uncomfortable waiting until we know more. And that is why I try to choose to send my energy towards thoughts of healing and hoping that there is comfort for all those involved. So that is that is where the heaviness for me is coming in. It has been a very heavy, heavy week. And so, though we will be talking about some lighter cases today, that is where my own internal heaviness is coming from. So, you guys are going to see it. It just is, it is, there's no box to put those feelings in. Those feelings are just there, but we're going to continue to talk. And again, one of the things that I love about Peter so much is that Peter taught me to not take YouTube so seriously. I've been watching him as a creator long before he and I connected and became friends. And I when I was thinking about tonight, and I'm like, I don't want to be a mess. First of all, I think dumping on your audience is my least favorite thing that content creators do. I want to share in space with you in a healthy way and not in a unhealthy trauma dumping kind of a way. And finding a way through that and to do that, really, it's one of the things I look at Peter for, because he makes so much content and is such a fixture on YouTube and loves this platform so much. And I was like, no, we are embracing the YouTube doesn't have to be perfect. And we show up and we have our long intros and we say, hey, you guys, it's Peter. Of course I'm back. I'm not going anywhere. And that is my hope for Peter, that we will see you around the interwebs after you are healed and when you are ready. And we are all going to miss you, and we love you, and you need the space that you need. And it will just we will see you when we see you. Take your time, because it is just that. But Peter taught me not to take YouTube too seriously, and to enjoy it, and to have fun, and to connect with your audience, and to share the love for this platform, and the love for content creation, and the love for living your life and being too much. And really, for me, and I don't think I've talked about this as much on this content, but for me, Peter's one of the first creators that I watched that was not a younger creator. We are older creators, and I always found so much, I don't know, camaraderie in that, and I love that. So I am I am appreciated. I am appreciating all the blue hearts. And I told the text crew, um Peter's thing with his audience is the blue hearts, and I love that. So I asked for blue hearts tonight from the text crew, and I love seeing them in the chat, because again, creators touch our lives in a different way. And I'm just, I don't know. I'm just really heavy knowing that that my friend is hurt, that so many were hurt, and that this is going to be a journey. So that is where the somberness is coming from me. And we're going to continue to do the YouTube's things. I don't even have a fan. I need a fan. We're going to do the YouTube's things, because that's what we do. We do the YouTube's things. And I love being here with you and holding space. And I think it's really important to talk about, especially from the legal side, about um, how hard it is to wait, and to wait for answers. And it's something I learn over and over again, and I find it very frustrating. It's even why it's hard for me to watch trials, because they like go to sidebar, and I'm like, I want to know. What are you saying at sidebar? I used to be a part of those conversations. I want answers. I want to know all the things. And that is a very human desire. And sometimes it's just not time to know all the things. And with that, I'm going to roll our intro, and then we're going to get into our topics tonight. I'm going to do a quick weekly roundup, and then we are going to talk primarily about the Prince Andrew settlement, the new Erika Girardi lawsuit, and all of the stuff going on with Jen Shah, because we're just going to lean into housewives this evening. And I will give a a brief kind of roundup of some of the other cases that are going on, but some of the heavier ones are just not going to be for tonight. So with that, it is time to roll the intro and take a deep breath. And I love seeing where you guys come in from. I do. That's what I should have grabbed, Melissa. I should have grabbed my under eye roller. It's in my bathroom. That's exactly what I should have grabbed. You're brilliant and I appreciate you. And that's what I should have grabbed. Next time I will grab my Sutton under eye roller. I might have to message Dr. B and be like, grab the roller. Thank you for that. Let's roll the intro. It's great to see everybody. Let's just roll the intro. Me talking like it's not me that pushes the button to roll the intro. Because it is. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So the thing is, Cindy hit it on the head. Like it's been a long week anyway. But also the thing is, I am a pretty boring person. I love my house. I hang out with my family. I am kind of a homebody. I like to read and watch TV and talk about law. I mean, I read lawsuits like all the time because I love doing this. And I am pretty boring generally. But well, yeah, I life is not full of excitement. Sometimes we get to, Taco Bell, and that feels exciting. Those Doritos Locos Tacos are good. If you watch this week's podcast, you know what I'm talking about. But Middle Tennessee keeps me on my toes. Because the weather is just like, hey, today it's going to snow. Tomorrow it's going to be 75. So this week, from a Middle Tennessee perspective, has been wild. And then life has been wild. And I think life has been wild for all of us. Like everyone I've talked to, they're like this and this and this and that. So wild. Thank you all for saying hello and coming in and telling me where you're watching from. I appreciate all of you. So yeah, all of you are like, get the roller. I know. We should Sutton it up. We're talking about Beverly Hills tonight too. Yep, we are. So let's do our weekly roundup. Let's start our week. We're 12 minutes in. This is going to be the kind of night. It's going to be this kind of a night where I'm just like, buckle up. It's just going to be like that. Oh, Adam, it's good to see you. Hello, friend. We know you're coming in from Ireland. Are you actually in Ireland at the moment? I haven't been on social this week. I don't where in the world is Adam McIntyre is a whole new game. I'm drinking very green kombucha tonight. So Jennifer, thank you. Sending hugs to all of us that need it right now. Thank you. And I think a lot of people need hugs. It's just, I mean, watching from Ottawa, life is definitely wild. Nicole, we're sending you hugs too. All of the Canadians, we're sending you guys hugs. It is a heavy look. The last few years have just been fucking heavy. It's like, thank God some Real Housewives have gotten themselves into some fuckery, so we have something to talk about that is lighter, but the world has been very heavy and it just feels like it keeps piling on. API says, hey, Emily, first time I've been able to catch a live in a while. I wanted to thank you for your mentions about Erlin lenses. I wouldn't have known I could get a custom tint to help with my migraines and light sensitivity. That makes me so happy. It's literally why I share what I'm going through, because my custom lenses have made a world of difference to me. And just on a quick story before we completely move on tonight, we were able to go, and this is somewhere I haven't been able to go and have not gone, but my youngest wanted to go to Dave & Buster's for his 10th birthday. So G wanted to go to Dave & Buster's and play video games with the families all day. That's what he wanted to do. Dave & Buster's is the kind of place that in my life formerly, before my Erlin lenses, before I started figuring out light sensitivity and noise sensitivity and all that stuff, I could not have gone. It would have triggered migraines. It would have been awful. I probably would have gotten dizzy and nauseous and all the things. But our whole family has Erlin. We all wore hats and we spent a wonderful day at Dave & Buster's for his 10th birthday. And he just had the most fun. We played all of the games. I beat him at bowling and nothing else. And yes, I tried, because I don't believe in letting my kids win by the time they're 10. I'm like, you got to earn that shit. Get it. And we had just such a nice time. And it was really because I have found things that work for me, which is why I share them. So Skylar Field said, "Fluff the aura." I know, and I have my napping emotional support beast behind me. George is emotional support, supporting with my older child because that is what George does. But yes, we will fluff the aura. I am very excited for some Real Housewives of Salt Lake City. I am just ready. Okay, let's get into the weekly roundup. I have some news that I don't want to share that I'm going to share that I hate. I hate it the most. I hate the first story on the weekly roundup. I'm looking at it in my notes going, I don't want to have to say that. But we're going to have to let's in the Wendy Williams case. For those of you not following along, Wendy Williams is fighting with Wells Fargo over her frozen assets. There has been such a lot of back and forth. And look, if Wells Fargo is genuinely concerned about whether there is undue influence and things like that with regard to Wendy Williams, I have a lot of questions about whether there was another way to go about this. But I am not a banking provider. I have a lot of questions. It seems extreme. It seems that they took the most extreme route possible in filing for a conservatorship. It seems to just be a financial, not a medical conservatorship, and in freezing literally all of the assets that Wells Fargo has. They asked for certain filings to be sealed. If you would like to watch my whole breakdown and what I think on that, there are times that I thought, oh my God, maybe I wasn't fair enough to try to see both sides. I really tried. It feels like such an extreme response. If they're worried about undue financial influence, it still feels very extreme to me. It does. Their motion to seal the case has been granted. So everything is now sealed, which means we are not going to know much more about this case. And that just it just makes me so mad. Why does it make you so mad, Emily? Well, I feel and I think it's because part of it is that in the Britney case, we saw how much wildness went on. And I'm not saying that this is going to be like that, but I think transparency is one of the things that helped in the Britney case because others could see what was going on and others are not going to be able to see what's going on here. I completely understand that sealing documents that talk about specific medical concerns should be sealed. It is no one's business, specific details, but those things can also be redacted. Sealing the entire file is a lot for me because there are two parts of this. There is the motions with Wells Fargo to unfreeze the assets going on, and then there is the second part of it where Wells Fargo is asking for a guardianship, which is essentially a conservatorship. It's just same name, same thing, different name. So I don't love at all that the entire case in not the conservatorship part, not the guardianship part, the entire case where they are suing for a preliminary injunction and temporary restraining order to have access to Wendy Williams's funds. This just it keeps everything out of the public eye. And again, I think there is room to redact information. I think there's room to redact specific medical or financial information. I think sealing the entire thing is a big move. I try to trust that the courts have people's best interest in mind, but also sometimes I've been burned by that. So I'm just concerned and nervous about what's going on here. And I am concerned and nervous about what's going on here. So I am trying to be optimistic, but all we know is that on February 16th, the court has sealed it. What we will be able to see going forward is what has been filed. So that's all we're going to be able to see, what's been filed. And sometimes that's not helpful. The letter correspondence to the judge, we know what it is because we got it before it was sealed. That we could see it, but this is sealed. So with that, this is not And just to be clear, this is not the guardianship part of the case. That part is sealed. This is the petition for the preliminary injunction and temporary restraining order to get access to Wendy's financial accounts. This is not the guardianship part. So I'm worried and concerned. That's where I'm at. I'm going to keep checking in on it, and maybe Wendy's legal team will fight this ruling to seal everything instead of just sealing parts of it. This is something Wells Fargo asked about and was granted. So, okay, so there's that. I don't like it at all. I don't like it at all. But if you guys have more questions about that, absolutely go watch the video where I broke down everything in those documents, because we got to everything before it was sealed. So go watch that while it's there. I hate saying that, but also I'm like, well, it's all been sealed now. I just don't love it. I don't love it. I don't. There's something else we're going to address in a address but not address kind of a way. In the Rust set tragedy that took the life of Helena Hutchins, her family has now filed a wrongful death lawsuit. They had a press conference. They released a video recreation of what they believe happened when Helena was shot by Alec Baldwin during not the filming, during the staging of the film Rust. I mean, I guess it's during the whole filming process. They weren't filming when that happened. I was going to cover that a little bit tonight. I am just not. I just cannot. So with that, I'm going to do more of a dive into the wrongful death suit for next week's podcast. So it's there. I will be covering it. I'm just not covering it tonight. If you guys are curious, you can find the wrongful death press conference from Helena Hutchins' lawyers and see what they had to say about it. I will absolutely go over it. I just do not have the bandwidth to go over it this evening. It is heavy. It is sad. And I want to go through again that wrongful death suit, because here's what I would like to do. In my mind, I want to look at what's said in the wrongful death lawsuit and look at what has been said in the armorer lawsuit and the script supervisor, Mamie Mitchell's lawsuit, and the gaffer's lawsuit, and and Baldwin's statements and pull all of those things together so we can kind of piece together what's being said in the wrongful death lawsuit, what's being said in the other lawsuits, and kind of line those things together. That's how I'd like to handle it. And that's what I'll be doing in next week's podcast. It's going to take me a little bit more time to just put that timeline together. So that's where it is for me, but that has been filed. We knew that was going to be filed, just didn't know when. I wonder if, because the reconstruction was, I don't think, done for court purposes. I think it was done for demonstrative purposes, possibly to show to the producers and to Alec Baldwin and others and say, hey, this is what we think happened. Do we settle this suit now? Are we pushing law enforcement to make a decision? What are we doing here? So I wonder why they spent the time and the energy to recreate that. And that's something I'll be addressing in the podcast next week. It was on the docket for tonight. And then I was like, I can't docket this, but we can talk about some more judicial stuff that's going on that I saw a lot of questions about, and questions are warranted about this one. Oh, did I download me in my brain? I'm worried that I didn't download the court's ruling, and I really, really wanted to. Okay, I can just pull it up here. Let's see. We've pulled it up. Before we get to that, we are going to be talking next about another defamation lawsuit. This is not the like all defamation legal coverage all the time channel, but there's so much of it, and I feel like we're getting to a fever pitch where defamation law is going to be changing, and where we're going to see the New York Times versus Sullivan test getting pushed and pushed and pushed. And we've had so many different examples of different types of defamation lawsuits that we are going to touch on a little bit what happened with the Sarah Palin New York Times lawsuit. Sarah Palin being a polarizing figure aside, we are going to talk about the judge making a statement while the jury was still out and what that looks like. So that's the court process we're going to be talking about. But before we talk about that, we need to talk about your internet privacy, and we need to talk about today's sponsor. I appreciate so much that NordVPN sponsors our streams because it allows me to cover things like the Prince Andrew settlement that's going to immediately make YouTube cranky, and they're going to be like, none for you. So Nord is like, no, it's okay. We've got you. And I appreciate that. And I think you guys will too. Nord is what I use, and I wonder if it's what you might use. And if not, you can get a deal. Let's go. A huge thank you to the sponsor of today's stream, NordVPN. You know, I've been working with NordVPN for quite a while now, and I'm so happy to do so because if you are not yet taking your cybersecurity seriously, it is time. It is time. This is your sign to start worrying about the information that you are sending out across the interwebs. If you're wondering, Emily, what's a VPN? A VPN is a virtual private network that allows you to connect securely from wherever you are on Wi-Fi, including and especially while you're traveling. Nord works on up to 6 devices, which is fantastic because you can make sure that you are protecting the entire family of devices that you work with, or your entire family if you have kids using the interwebs from iPads and laptops and things like that. Protect your search data with Nord's encrypted privacy, and Nord doesn't keep any logs, so they're not tracking what you do. And if you're wondering, but is this going to slow down my web surfing? I've got you. I know I don't want any of my stuff slowed down, but Nord has the fastest connections out there. So with our exclusive deal, use code Emily D. Baker or go to nordvpn.com/Emily D. Baker to get your exclusive deal. Why not try it? With Nord, you get a 30-day money-back guarantee. So go ahead and give it a try. Use my code down below and let me know how you're liking NordVPN. Thanks for sponsoring another video. So as we finish our roundup, I'm just going to talk real quick about the Sarah Palin versus the New York Times. And again, because Sarah Palin is a polarizing figure and political figure, it's easy to lean political. This case is only political in the fact that there's context that's political. This is a defamation case. If you hadn't been following it, I get it. There's a lot going on. Sarah Palin sued the New York Times over a editorial that essentially linked her PAC to a shooting that wounded Representative Gabby Giffords and killed 6 others, and then was later retracted and corrected. So that is kind of the context of what the defamation was. The issue here was that while the jury was deliberating, the court said that they would grant a judgment as a matter of law. So some of you are going to be like, oh, wait, a what? I get it. What's a what? So sometimes this is a judgment notwithstanding a verdict or a judgment as a matter of law. I don't know why the judge let it go to the jury. That's a question that I still have, because you can make a motion, and I don't know if the defense did this or not, because I did not cover the or follow this trial super closely, but you can make a motion to dismiss at the end of the plaintiff's case, saying, as a matter of law, the plaintiff has not proven what they need to prove. This can't even go to the jury. Just dismiss it outright. And the judge, I don't know if that motion was made, and if it did, it clearly wasn't granted. But while the jury was deliberating in this civil defamation trial, the judge made the ruling that the judge would issue a judgment notwithstanding a verdict, meaning it doesn't matter what the jurors do. I don't believe as the judge that there is enough facts to prove that there was defamation here. And therefore, my judgment is that the New York Times is not liable because there's not enough evidence for a jury to find liability on the part of the New York Times. The issue is that it came down to proving malice and actual malice. And this is something we talk about with public figure cases, and we talked about in the Cardi B case quite a lot, is where you find malice and actual malice. This how do you prove, and malice not meaning like, I hate you, but malice in the New York Times versus Sullivan sense of the word, proving that they knew it was false, this disregard for the falsity of the statement, and this actual malice in going, I knew it was false. I don't give a fuck. Screw you. I'm doing it. It's the hardest thing to prove. And it's why a lot of defamation cases don't go forward when you look at things and are like, hey, um, why isn't that person suing for defamation? And it might really be a calculus of, oh, bless you, Fred. It might just be a calculus of, hey, proving actual malice here is going to be hard. Not everybody's a YouTuber that talks about all of their thoughts, like like Tasha K, because those videos were used against her as Cardi B was proving actual malice in her case that she recently won. So trying to prove actual malice is very hard. I break down defamation in a lot of other videos. I'm not going to if we get down the rabbit hole, I'm just going to go all the way down the malice rabbit hole, which we're not doing. So the court found that under New York Times versus Sullivan, the actual malice standard had not been met. It is very hard to prove. And the judge made that decision before the jury came back and said, I'm still going to let the jury come back for purposes of appeal. But it seems clear that a number of the jurors got news alerts on their phones. And the news alerts were that the judge had determined that the case should be thrown out because there was no malice. But they were not done. So the jury was still out. This is not a case. Just look, and again, I've looked at this briefly. Maybe this is not fair to say, but I'm going to say it anyway. I've looked at this briefly, and it seemed that the behavior of the New York Times after what was said, was going to always make this an uphill battle from the start. So I don't know if that's the fight you want to pick. I just don't know if that's the fight you want to pick. But the judge, it was interesting to me that the judge made that ruling while the jury was still out in a way that it was released to the public. And that, courtrooms are open. Yeah, the judge could have pulled the attorneys in chambers and said, this is how I'm inclined to rule, to let the attorneys know. This is how I'm inclined to rule. And I am keeping that, I'm not putting that ruling on the record until the jury comes back because this is a high profile case and a media case. I'm asking no one to discuss it. It was very odd to me that the judge decided to make that a public ruling while the jury was still out instead of, you could have given a heads up to the attorneys in chambers altogether and then said, if the jury comes back, this is going to be a judgment notwithstanding a verdict. I am going to rule on this. We'll see what the jury does, but I don't want this to get out. Instead, it was everywhere. Like the judge is ruling this, Sarah Palin loses, jury's still out. So here's the order that the judge just issued to deal with that issue, that nonsense, that poorly timed or not the best execution of the thing. It's just not the best execution of the thing. So let's pull that up right now. Do we have everything together? Kind of, sort of. I hate pulling it up when I see this on the site. Can I get rid of this? There. I fix things on my own. Y'all, I know normally the law nerds are like Emily tech support, but we fixed it. That's right. Avalmia said unforced error. Exactly. I don't know if it will matter. Because if there's not enough evidence, there's not enough evidence. And so the judgment notwithstanding a verdict was always going to be the judgment notwithstanding a verdict. So even if the jury had come back with liability, the judge is still going to be like, the facts don't meet the law. So you can't do it. So yes, Scorpion, this is a fantastic question. When I finish this order, I will touch on that. And the question for those of you that are just listening and don't see it on the screen is, why have a jury if a judge can just overthrow what they decide? That is a very good question. We'll talk about it. But you can have judgments notwithstanding a verdict, saying that the jury could come back and say guilty, and the judge can say, yeah, there's not, as a matter of law, the facts don't meet the standard. So let us continue with what the judge said. Jed Rakoff said, It is the court's uniform practice after a verdict has been rendered in a jury trial to have the court's law clerk inquire of the jury as to whether there were any problems understanding the court's instructions of the law so that improvements can be made in future cases. By the way, I will just say, as a trial attorney who did trial work a lot, that's common practice for almost every judge I practiced in front of, to talk to the jurors, to ask the jurors if there was anything they can do. Judges want the jury system to be juror friendly, and the only way to do that is to really ask the jurors. So that's super common. Late yesterday, in the course of such an inquiry in this case, in which the jury confirmed that they had fully understood the instructions and had no suggestions regarding jury instructions for future cases, several jurors volunteered to the law clerk that prior to the rendering of the jury verdict in the case, they had learned of the fact that the court's Rule 50 determination on Monday to dismiss the case on legal grounds. Mhm. These jurors reported that although they had been assuredly adhering to the court's instruction to avoid media coverage of the trial, they had involuntarily received push notifications on their smartphones that contained the bottom line of the ruling. I got them too. I got push notifications too. I have news alerts on my phone too, because this law shit. Look, Tuesday, I was like, y'all, today is not the day. I cannot stream. I need a pause. Everything happened on Tuesday. Like, all of the things happened. And my push notifications were just like, it just wild. Push notifications on their smartphones that contain the bottom line of the ruling. Yeah, they did. The push notifications were like, yo, the judge is dismissing this case. The jurors repeatedly assured the court's law clerk that these notifications had not affected them in any way or played any role whatever in their deliberations. I personally find that to be sus, just based on human nature. Just based on human nature. How do you see that the judge has determined as a matter of law that the case is going to be dismissed and then still deliberate and go, well, I guess we can really do whatever we want? What? It's like, well, I think if I was a juror, particularly not a lawyer, and it was like, oh, well, the judge already was going to dismiss it. So I guess, that kind of maybe means there's no liability here. I can't imagine that plays no role in their deliberations whatsoever. It's just, I wonder if they're afraid they'll get in trouble. Like, I really just wonder if they're afraid that they'll get in trouble. But this came out after they reached a verdict. The court also notes that when it proposed to the parties during oral argument on Monday morning to render its Rule 50 decision later that day, but to permit the jury to continue deliberating so that the Court of Appeals would have the benefit of both the court's legal determination and the jury's verdict, no party objected to this plan. I don't think the parties conceived that the push notifications would go out. This probably should have been discussed in chambers, not in open court, but okay. Nor did any party object when the court reconvened later that day outside the presence of the jury, and the court indicated that it was prepared to issue a Rule 50 decision at that time. That's probably when they should have objected. I mean, probably. Indeed, no party objected to this procedure at any time whatsoever. The court feels a little, I don't know, maybe it's me. I'm having a day. It feels a little defensive. It's like, y'all didn't say no. Y'all didn't say no. Nevertheless, in an excess of caution, the court hereby brings the foregoing facts to the party's attention, which is totally fair and I think upstanding of the court to do. If any party feels that there is any relief they seek based on the above, counsel should promptly initiate a joint phone conference with the court to discuss whether any further proceedings are appropriate. I don't like the timing of how this all went down, but I think at the end of the day, it's not going to have a ton of impact because the judge already said, as a matter of law, all of the facts that you presented can't meet the standard of defamation. So an appellate court can't turn around and be like, hey, court, we disagree. No, the appellate court's not going to disagree. The appellate court's going to go with the trial court's finding of fact. And the trial court's finding of fact is, hey, There's not enough here for it to be defamation. I really think that procedurally, the court should, being mindful that this is a media trial, being mindful that the media is going to run with this, should have told the lawyers in chambers and issued the order after the verdict. And that might have seemed strange to people, but the ruling has the same impact whether it's issued before or after the verdict. The verdict ended up being a no liability for the New York Times anyway. I don't think this has a lot of impact, but I hope that it's instructive to other judges that even when you make this ruling, you can go ahead and do this in chambers and not issue the ruling, because um, once it hits the media, they're going to run with it, and push notifications are a thing. Even if the jurors didn't have their phones in the jury deliberations room, which most of them shouldn't have been, um, you will still go home at the end of the day, right? They're not sequestered. You're still going to go home. And when you turn on your phone at the end of the day to check if you have emails from work or need to talk to your spouse or need a text message, those push notifications come through. And so I think the only way to have avoided that was to issue the ruling after the jury. So, or after the verdict, after the jury verdict came down. Those are my thoughts. I don't think it's going to have an impact. But I do know that a lot of people were confused that judges can do this and just be like, "Wait, what?" Um, you can have a jury reach a verdict and then the judge can say, "Nah." Yes. It's rare that that happens, but yes, that can happen. The judge can say, "I don't think the facts proven meet the law," and that's what would have happened in this case. If the jury had come back and found liability for the New York Times, the judge still would have made this ruling and not held the verdict. It would have still been a judgment of the court notwithstanding a verdict, and that can happen. So, I thought that for that reason, this story was interesting to cover. I don't think that this case ever really got lift because of the actions of the New York Times after, because of the retraction. Proving malice in that case is going to be very, very hard. So courts are going to have to find a way to think through these things, and lawyers are going to have to find a way to think through these things, because when you're in the middle of trial, your brain does not process like a normal human being. You are so into what you're doing, it's very hard to take a step back. It's easy for me to sit on the internet and go, well, maybe you should have done this. I'm not the one in the trial. I'm not in trial brain. I'm not in mode. I have not eaten Cheetos and Coke for lunch for 3 days, and Coca-Cola, not the soda. I have not, and there were more than a few trials where I ate Cheetos and had a Coke for lunch, and that was it for days. You know, you're not running on dehydration, no sleep, and poor nutrition. I'm just sitting here on the internet getting to look at it objectively, being like, well, maybe it would have perhaps been better if you had done this. But it's something that lawyers and judges are going to have to consider moving forward, is the impact of technology. And technology moves faster than most lawyers do, and technology moves a lot faster than most lawyers do. So I hope that as we continue with like continuing legal educations, they talk about this more, because these are things that are, I don't know. I think this is a lesson for all courts, because it didn't have an impact here, but it could have an impact in a different type of a case. And that prolongs the cost of litigation for everybody if this goes appeal after appeal. I don't think this will get appealed. I think this is just like, okay, are we done now with this case? I also think it's going to be interesting watching how the courts continue to deal with New York Times versus Sullivan. I don't necessarily think it's a bad thing that the actual malice standard is high, because there is a difference between just saying shit and actual malice. But it does make it hard, and I think that the actual malice standard and who's a public figure and who's a limited purpose public figure in the age of social media, we're going to see some shifting in the way that these laws are interpreted, because they weren't written in a time when it was accounting for things like Twitter and how fast information can spread and how wide information can spread from whomever. So, mm, yep. Yep, yep, yep. Yep, yep, yep. So, I will say my diet since I have left the DA's office has gotten better. I actually do try to eat real lunch most days. I personally don't consider Cheetos and a soda a real lunch, but again, when you're in that mode, sometimes that's just what it is. I know there are lots of attorneys who feel me. There are days that it felt like, for me, justice ran on like fun size candy bars and chips and at all. So that's what happened with the Sarah Palin defamation lawsuit. I was confused that that was the order things went down in. We should move on. We should move on. It is time to get into the rest of the things. We are going to talk about the Prince Andrew settlement. I am going to give a warning. People have, well, this is not a warning for me. This is a reminder. People have very strong feelings about this. I will remind you that however you feel about this, that trying to shame the plaintiff in this case is not going to be well received by me or the mods. I can understand questioning why somebody would settle. Fine, but we're not going to shame or blame people for settling, and I'm going to talk about why in just a minute. So let us move on to the Prince Andrew settlement, keeping our open minds and our compassion all intact as law nerds while we have this discussion. I was surprised. A lot of you weren't. On social, I said, I'm surprised. Are you surprised? Because I'm surprised. I am surprised this settled for a number of reasons. One, Virginia Giuffre, sued Prince Andrew after years of other types of litigation. I mean, this is not the first litigation dealing with Epstein, dealing with Maxwell at all. This is not the first litigation around this entire trafficking operation. When it came to the Prince Andrew lawsuit, because this has Prince Andrew's name has been connected to this for years and years and years, as have others, based on other court documents from litigation years ago. There was settlements and there was a victim fund. There has been lots of things that have happened outside of this, this lawsuit. So when I saw this lawsuit, I was not surprised. I was not surprised that her lawyer, David Boyce, remember, the attorney that was brought so heavily in to all of the things going on with Elizabeth Holmes and Theranos, because he was the attorney that was reaching out to the whistleblowers, which is very interesting, but it is what it is. So he's there. So David Boyce had made statements on behalf of his client, Virginia Giuffre, and said that a purely financial settlement was not what she was interested in, that she was interested in a settlement that would contain more of an expression of guilt. I put all of his, Emily, just pull it up. I put all of his statements in my blog post about it. Yes, sometimes I blog things, and I went back through and found them. So maybe I should just share that with you, because I quoted it there, and now my brain is like, where are those notes? And I'm like, well, it's just on the blog, so we'll just pull it up from the blog. So let's just do that. All right. Me citing me. It's very meta. It's like when lawyers that I worked with got to cite themselves from law review articles that they wrote. It was very, let's go to the case settlement part. Okay. Let us go to what David Boyce had said. In a statement to BBC Newsnight in January, attorney David Boyce stated that Virginia, was not interested in a purely financial settlement, saying that it is important that the matter is resolved in a way that vindicates her and vindicates the other victims. Further stating that what's going to be important is that this resolution vindicates her and vindicates the claim that she's made. Boyce said that there have been no settlement discussions so far, but said that, quote, a purely financial settlement is not anything that I think she is interested in, end quote. That was in January. So that was a very recent statement that she was not interested in a purely financial settlement. You will let me know if you believe that this is a purely financial settlement. I'm going to pull up the settlement and we're going to go over the notice that was sent to the court. There have been rumors, speculations, leaks, I don't know what you want to call them, that this number is somewhere in the £12 million, which would put it in the $20 million-ish range. That is a number that has been thrown around, but this is an undisclosed financial settlement. So let's talk about this settlement. Judge Kaplan, who I have enjoyed Judge Kaplan, by the way. We write jointly with counsel for defendant to advise the court that the parties have reached a settlement in principle for the above referenced action. The parties anticipate filing a stipulation of dismissal of the case within 30 days, and that'll be a dismissal with prejudice. You cannot rebring these actions again. In the interim, the parties request that the court suspend all deadlines and hold the action in abeyance. Yes, please pause. Stop right there. Thank you very much. Stop. We're going to stop everything. Stop all the deadlines so that the clock doesn't keep ticking. Because if the check doesn't clear, essentially, then we will be on again. They go on to say that Virginia and Prince Andrew have reached an out-of-court settlement. The parties will file a stipulated dismissal upon Giuffre's receipt of the settlement, the sum of which is not being disclosed. So with that, Alicia has corrected that 12 million pounds is about $16 million. Thank you. I appreciate that very much. So the stipulated dismissal or the agreed upon dismissal will come after the receipt of the settlement, the sum which has not been disclosed. Prince Andrew intends to make a substantial donation to the charity in support of victims' rights. So these are two parts, as I see it, that there will be a settlement directly to her and also a substantial donation to her charity that will then become public. Prince Andrew has never intended, and this might be the statement that was enough that this is filed as an addendum to the notice to the court, that this is the public statement, and that this is what they have agreed upon will be the public statement about this case. And then we will talk about this a little bit more in a minute. Prince Andrew has never intended to malign Miss Giuffre's character, and he accepts that she has suffered both as an established victim of abuse and as a result of unfair public attacks. So that might be as close as they were going to get to her getting an acknowledgement of anything. That might be it. That might be the acknowledgement of anything. It then goes on to say it is known that Epstein trafficked countless young girls over many years. Prince Andrew regrets his association with Epstein and commends the bravery of Miss Giuffre, and the other survivors in standing up for themselves and others. He pledges to demonstrate his regret for his association with Epstein by supporting the fight against the evils of sex trafficking and supporting its victims. I think that's it. I think that's it. I think that's all of the acknowledgement that is happening. I think that's it. I think it is a never intended to malign, accepts that she has suffered, not at his hands, but as a victim of abuse. He's not saying his abuse, but she has suffered, and that Epstein was bad. I think that's all. So I think that's all. Now, what I will say is this is a civil case. So when we look at what was being sued for in this case, the remedy was always money. It was always money. This is a civil case looking for a civil sum. This could have gone to trial. Look, it would have gone to discovery first. It would have gone through depositions. They were going to have to deal with trying to authenticate the photo of the two of them together that supports her story. She was going to have to relive all of this, not just in deposition, but on the stand. His attorneys were going to absolutely drag her through the mud, because that is what I shouldn't say that's what defense attorneys do. That is what the other side will do. Plaintiffs' attorneys do it to victims. Defense attorneys do it to plaintiffs. That is what happens. So with that, this was always going to be a financial case. How much it aired dirty laundry, was always going to be part of the consideration for Prince Andrew and going forward. I personally think that he had more to lose than she did. She has already been dragged through the media. She has already been put through it and has been fighting for public acknowledgement of what happened. So, with that, and him losing his titles, I wonder if that was enough, that it was like, "Okay, this is enough." And with it being enough, this is a financial settlement that is large enough that she was like, "You know what? There is no need to take this any further because it's not easy for anyone to be a plaintiff in a case. It is tremendously difficult. And I will say there is a YouTube channel that I'm going to bring up real quick and share because I think I was just watching them the other day. I'm going to pull up this video exactly so I can show you. There is a channel that a few law nerds brought to my attention called Footless Jo. It's an incredible channel. She talks about all kinds of her her experiences with being I'm trying to make this bigger and it's just not helping. Where is the I'm trying to find a particular video and trying to talk with her experiences as an amputee. And she has a lawsuit story that she shared. And that is the video I am trying to find to see what the title of it is. So I can just direct you to it. And so I can give the link to my mods so they can put it in here. She is an incredible creator, shares a perspective that a lot of us don't have. And haven't had because that hasn't been our experience. But she has a lawsuit video and talks about her experience as a plaintiff here we go, as a plaintiff in a lawsuit where she was harmed by the negligence of a restaurant. And let me see, this was 4 months ago. Let me can I just where can I just want to grab the link. I think she's a tremendous creator. So let me grab the link and I'm just going to give it to the mods so they can put it in the things and I'll put it here. So I think she's amazing. If you are A, she's a great storyteller. B, she has been through so much and really shares that. But if you are curious and do not know what it is like to be a plaintiff in a lawsuit, her video of her experiences as a plaintiff in a lawsuit is very common. And her video talking about how much she was put through as a plaintiff is sadly the common experience that plaintiffs go through and is just horrifying. So if you don't have that perspective and want to see what somebody who's been through a lawsuit goes through, her story is very powerful and she shares it so well to um to help people understand what that process was like. So with that, I can understand why when the end of a civil lawsuit is money, a jury's going to decide how much money you get, that there is some point where plaintiffs are like, at what point is enough enough? And at what point do I need to protect myself, my sanity, my heart, my emotions, and not do this anymore? And at what point do defendants in civil suits say, um, I might not be ever able to clear my name with everything that's happened. So if we can just stop here, then we can just stop here. So I highly recommend the Footless Jo video if you want to see what a plaintiff's experience is like. And in the Footless Jo video, she is like a plaintiff you would learn about in law school. She had a devastating slip and fall through absolutely no fault of her own, a very common situation in plaintiff's law where somebody slips and is injured, and the defendant, the person who gets sued, takes a plaintiff as they are. So it doesn't matter that one plaintiff might get more hurt than another plaintiff. It's it's the responsibility of an establishment to not be negligent. So it's a very interesting perspective on someone who literally did nothing at all wrong. They existed, they walked into somewhere, and they slipped because of somebody else's negligence, and then breaking that down. And so seeing that, you can get an understanding of what Virginia will go through and has gone through with this lawsuit and can continue to go through. So it's a very difficult thing to be a plaintiff. It's a difficult thing to be a civil defendant. Civil lawsuits are hard. So with that, I can understand why it settled, but I was surprised that he settled. I was also a little surprised she settled. He has a lot to lose, but at the end of the day, how much is a jury going to award her, and how much is she going to spend in legal fees, and how much more emotional energy after Maxwell got convicted? How much more? Like, how much more is worth it? He lost his titles. How much more? So that I can understand. I was more surprised about him agreeing to settle, but a lot of you, especially those who are Brits, are like, I'm not surprised at some point that the family put their foot down and was like, I don't care what it costs. Just so. And some of you are asking in the chat, and this is what I love live streaming for, and what I love about the chat is you guys are like, but how much could she have gotten? A jury could have given her $2. A jury could have given her $20 million. I mean, a jury could have given her, depending on how outrageous they thought to do, or how outrageous they thought the actions she detailed to them were, if they all believed her and if they all found that he was liable for the battery, then what could it have been? It could have, her attorneys probably have a better sense than I do. How much could that have been? But also, that's the amount she could have gotten is going to be reduced by how much her attorneys are spending and how much it costs to go through trial. So the amount she'll walk away with now is probably going to be more than the amount she'd walk away with after trial, because the legal fees would just be higher. So she'd get a smaller percentage. So do I think the settlement in a 10 million range is, like, when I hear that number of 12 million pounds, does that sound off to me? No, that's like, well, I can see that. So I can see that. I can see a settlement in that range. So that doesn't shock me. I'm not like, oh, shock me with your deviant behavior. No, I'm not shocked. Empire Records, I'm not shocked by that number. But that's also not the area of work that I ever did. And those numbers to me are just like, once again, it's by seeing other things. Natalie Lawyer Chick, it's so good to see you in the chat. I love Footless Jo too. I love it when the law nerds are like, are you aware of this creator? And I'm like, no. Or I'm like, yes, I love them too. So anyway, I'm not surprised that the Crown wanted this to go away. I'm not surprised that everyone is just done. So it hurts my heart that this is such a polarizing case. I mean, it's just, I don't know. I guess I have a different perspective on trafficking after doing the work that I did and seeing the things that I saw, that it's not these stories. Sadly, when I hear them, I'm just like, oh, yeah, that sounds about right. That's how that goes. That's how that goes. That's how that happens. That's how that happens. So anyway, let us move on. We have housewives to discuss. There are housewives afoot. Let us discuss housewives. Housewives, on to housewives. Fred is like, why are you yelling? I'm sleeping. I'm so peaceful. Sorry, Fred. Housewives. We're talking about housewives. We're going to talk about Erika getting sued, and then we're going to talk about whether or not the prosecution is going to use Jen Shah's clips on the Real Housewives against her. Housewives. Housewives. Let's just talk about housewives. Erika got sued again. Yay. Are we shocked? No, none of the shock. Here's the thing. I'm going to try to do a brief road so far. A brief road so far on Erika Girardi. All right. Edelson PC sued Tom and Erika Girardi and made a bunch of allegations. And the bunch of allegations kind of brought the media's awareness, and we all went, wait, what's going on over there? What did you say? You said sham divorce. Wait, you said $20 million loan. Wait, you said she's getting money from the law firm. What is happening? Then the freezing assets, then the bankruptcies, then all the other lawsuits kind of bubbled to the surface. They were there, but nobody was really looking at them because it was all kind of under the carpet. And we were all like, wait, what the fuck is actually happening? And then the earrings. So now there are two bankruptcies, a bankruptcy of Tom Girardi as an individual and a bankruptcy of Girardi Keys, the law firm. There is an ongoing contempt proceeding that has some new filings in it that we need to get into, but we're not getting into tonight. We're going to get into another night because it's fascinating. But we have a contempt proceeding going on in Illinois with regard to the Lion Air crash, the literal widows and orphans of it all. That is still ongoing to determine whether any of those lawyers have liability and that those lawyers are required to pay back the clients who were not paid in the Lion Air crash. It's about $2 million there. And then in the bankruptcy court, Erika Girardi got sued in the bankruptcy for the law firm. You can see my brain is like, it's so much. There is a map. I have a chart, but not tonight. So the trustee of the Girardi Keys bankruptcy sued Erika over property that it is believed went from the law firm, or it's alleged, I guess, by the bankruptcy trustee, went from the law firm to Erika that is the proper property of the law firm, meaning if it goes back into the pool of funds for the bankruptcy, it can get divvied back out to the bankruptcy creditors, of which Erika Girardi is also one. And so's the IRS. The IRS is like, hello, you owe us like $3.5 million. We'd sure like to get that back. The thing is, the bankruptcy stuff can't be discharged in bankruptcy. So even if they don't get it, they're going to be able to go after it. So that will be fine. So then outside of the bankruptcies, Erika and David Lira have been sued. You can't sue Tom Girardi and Girardi Keys because they're in the bankruptcy. So anyone that believes that they didn't get money from Girardi Keys needs to apply as a bankruptcy creditor and be like, look, I need this money. So outside of the bankruptcy, Erika and David Lira, Tom Girardi's son-in-law, are being sued by lawyers and the representatives of a client's estate. So the law offices of Manuel Miller. Manuel Miller is an individual. Kathleen, I can't even try because I'm not going to be able to pronounce her last name, and I don't want to do that badly. So Kathleen as a individual and as a representative for the estate of Charles Osborne. This is coming out of a large group of plaintiffs' cases that Girardi Keys dealt with regard to the NFL and NFL concussion injuries. So this is an allegation that Erika Girardi, aka Erika Jane, EJ Global, and David Lira, and the 1126 Wilshire Partnership got monies from the law firm that should have gone to this client and these other lawyers. Those are the basic allegations. I need to look at what the financial elder abuse is. This is a first look. These, again, it is a lawsuit. These are allegations and shade. These are allegations and shade at this point. So we are going to look at what their allegations are, and they concisely write it up, which is very helpful. Thank you, attorneys. Who are we thanking? Michael Colietti, Esquire, and the law offices of Michael Colietti. We appreciate you. Thank you for a concise introduction. Appreciate it. The plaintiffs, let's see. The plaintiffs with attorney Tom Girardi and his law firm Girardi Keys, pursuant to written agreements, and agreed to share in the attorney's fees when the case settled. When the case settled and the attorney's fees were paid out to Girardi to handle on behalf, and I spoke too soon. We appreciate an introduction. I said concise. I don't mean that. I said concise and I don't mean that. This could be, look, we appreciate an introduction, but when the case settled and the attorney's fees were paid out to Girardi to handle on behalf of and distribute, Girardi had a fiduciary duty to act with the utmost good faith in performing those tasks. That's true. But Girardi breached his fiduciary duty by misappropriating the funds and not dispersing them. Those are allegations, but I think it shouldn't be hard for them to prove whether the funds got dispersed or not. but the Girardi case books are a mess, which we know from the bankruptcy trustee. Defendants, wife and son-in-law, knew that Girardi was breaching his fiduciary duties. I would like to know how they knew. Erika knew. Son-in-law should know. Son-in-law should know because son-in-law was working at the firm during this period of time. But they're saying that Erika and son-in-law knew that Tom was breaching his fiduciary duties, but rather than put a stop to it, they aided and abetted Girardi because it benefited them financially. So that's the allegation. With this action, plaintiffs are not seeking to recover the funds misappropriated by Girardi or any amounts fraudulently transferred to defendants. Rather, plaintiffs are seeking to hold defendants liable for the damage caused by their tortious conduct. So not trying to recover the funds, but whatever damage came from the funds not being transferred. I'm interested into what those damages are. I'm also interested into how, at this point, they are alleging that Erika knew. But defendants Lyra and the others were partners at Girardi Keese and provided substantial assistance or encouragement to Girardi by abandoning their legal and ethical duties to stop the fraudulent activity at their law firm. I mean, that's a conclusion, but okay. Lyra and Does 1 through 20 provided substantial assistance and encouragement to Girardi by participating in the lulling activities that prevented plaintiffs from discovering that the attorney's fees that were owed had been stolen by Girardi. So what's interesting is if Lyra communicated with these, and Lyra has said to Law 360 that he does not know these plaintiffs, he does not work in these, he did not work on these cases, but if he knew and he was communicating with them saying, oh, it was this, it was that, we'll get there. If he was actively putting them off, then if they can prove that, then I can see where they would say, look, but you were the one stalling us in learning that these weren't getting paid out. Girardi's wife, defendant Erika Jane, knew about the scheme and that the victims, like plaintiffs, were funding her notoriously lavish lifestyle chronicled on The Real Housewives of Beverly Hills. I want to know how. And aided and abetted Girardi's breach of fiduciary duty and has direct liability for participating in it and facilitating the conduct. It's hard for me because we've got a lawyer and a non-lawyer. So the way I'm going to parse this in my brain is different because the lawyer has a different duty than the non-lawyer. If this lawyer was a part of the firm and engaging with the clients versus the spouse, there's a difference there, and there's a difference of a duty owed there. So I want to know why they think she knew and how they're going to prove it. Because what our gut says, my gut can say, well, of course she knew. Where'd she think the money was coming from? But as I've explained before, Girardi was bringing in billion-dollar settlements. So what's 40% of $1 billion? That's the legal fees. So the gut check of, but come on, didn't Erika know, is different than legally proving that she knew to the point where she owed a duty to these clients and breached that duty to where they are now suing her, or suing her as an aider and abetter. Defendants knew that plaintiffs were fraud victims, but did nothing to protect them and instead prioritized their own financial gain at plaintiffs' expense. Again, allegations and shade. Defendants should be required to compensate plaintiffs for the harm that they caused and should be punished for aiding and abetting Girardi's breach of financial duty and their financial elder abuse of plaintiffs. Plaintiffs' law office, well, there's no elder abuse of the law firm. Plaintiff Miller is, and at all times was, a resident of California, the sole practitioner of the firm. Kathleen is the representative of the estate of Charles Osborne and was a resident of California and was the plaintiff in the action in NFL players concussion injury litigation. Plaintiff's master administrative long form complaint versus the NFL. Defendant EJ. It's weird to me that these are dropping. Sorry, the text layout is odd to me because it almost looks like it's typewritten. And that's hard for my brain to comprehend that this would be written on a typewriter. But I'm distracted. Look, my ADHD dyslexic brain is now distracted by the fact that like some of these are dropping at the end of sentences. And I'm now questioning what kind of printer this was or what, see, look, drop, or whether it was typewritten and I am confused. and I am confused. Um, Mother of Cats asked the question that I want to know too. Why did Tom Girardi need to steal if he was making hundreds of millions of dollars? I want to know too where he got behind and felt the need to steal, or was it just greed? I have questions about that too. It is something I think about regularly when I go over the multitude and plethora of litigation here because it's so much. I'm not going to get into EJ Global. It's Erika's company. Did business at Wilshire. Let's see. On information and belief on behalf of EJ Global, defendant Jane acknowledged Girardi and Keese. That's an odd sentence. Defendant Jane acknowledged Girardi and Keese a $25 million receivable, has received values from that receivable. I wonder if they pulled this from the bankruptcy filings. Has never disputed the receivable and has never reported to the IRS or Franchise Tax Board that her jointly owned law firm filed a false this is more challenging to read. Just make them individual sentences. Just make them individual sentences. Has never reported to the IRS or the Franchise Tax Board, which is California's tax board, that her jointly owned law firm filed a false return to the IRS for at least tax years 2015 to 2018. I wonder if they have the returns. Do they have the returns? Defendant Jane also, I wonder if they got them from the bankruptcy court. Defendant Jane also received preferential payments, which she is being sued for by the IRS for at least tax years 2015 to 2018. And I have not seen that either. Defendant Jane also received preferential payments for which she is being sued by the Chapter 7 trustee in bankruptcy court. Kind of. These payments show her insider status and control. I don't know. The partnership, the 1126 Wilshire partnership, is a California general partnership. It owned the building, but I'm wondering if they so they're saying that defendant Lyra was a member of that partnership that owned the building where the law firm was. Defendant Girardi Financial. Is defendant Girardi Financial on here? Well, why not put defendant Girardi Financial in there too? I'm so confused. Okay. Where's defendant Girardi Financial? All right. Defendant Girardi Financial is in all relative times was a Nevada corporation at principal place of business at 1126 Wilshire. Defendants Jane and Lyra are officers or directors at Girardi Financial. Defendant Lyra is a partner at Girardi Keese up and until May 2020. Tom Girardi's son-in-law. Plaintiffs believe that Lyra enjoyed special privileges and compensation due to his insider status. Okay. Defendant Doe's 1 through 50 at all relevant times was a California resident. How do you know that if they're Doe's? The true names and capacities for the Doe's are unknown. I mean, I guess they're anticipating the Doe's are other lawyers. Is this typewritten? I have so many questions. Let's see. Defendants or plaintiffs are informed and believed and alleged that at all times mentioned in the complaint, each of the defendants was an agent, co-conspirator, servant, joint venturer, partner, employee, and or employer of each of the remaining defendants and was in doing the things complained of herein, acting within the scope of his, her, its agency, conspiracy, joint venture. So really liability through co-conspiracy or through agency, partnership, or employee. Lyra was an employee. Jurisdiction and venue in California. General allegations. Girardi's breach of his fiduciary duties. I don't think we have questions if plaintiffs and other lawyers didn't get paid that's a breach. It's a breach. That's what happens. This is now slanting and it's making my eyes hurt. Stop drifting on the page. Maybe it just uploaded weird. The NFL case was ultimately resolved with a cash settlement. When Girardi received the settlement funds, a portion of which Girardi had a fiduciary duty to distribute to plaintiffs, Girardi, Lyra, and Doe's 1 through 20 lulled plaintiffs into believing that the funds could not be distributed to anyone until various issues were first resolved. Where have we heard that before? in all of the allegations in the Edelson PC litigation and in the contempt hearings, where Jay Edelson, for one, when he was on the stand, talked about being assured, like, it's fine, it's fine, it's fine, it's fine, as part of the reason they didn't know that the Lion Air plaintiffs hadn't been paid. So these are very similar allegations to that. They go on to say Lyra and Does 1 through 50 participated in the lulling activities, the kind of putting off, and were specifically aware of plaintiffs' inquiries as to when payment would be made, and echoed Girardi's lies and or remained silent. Those are two very different things. Lyra and Does participated in the lulling to ensure that they would continue to receive funds from Girardi that they knew could only be paid if Girardi and the firm Girardi and the firm where they were partners breached their fiduciary duties to plaintiffs. Lyra and Does were also aware of other legal actions against Girardi and their own law firm alleging claims like those alleged in this action. This is okay. I mean, when did those things happen? I would like to look, law students, lawyers, say when the things happened. Just when did the things happen? They're alleging that Lyra, none of this says Erika, by the way. Lyra was involved in Girardi's affairs while he was working at the firm, and that Girardi was operating a scheme. That Lyra received the funds conveyed by Girardi, that those received funds with the full knowledge that the funds they were receiving and or aiding and abetting the diversion of belonged to plaintiffs and other victims and did not belong to their law firm. It'll be interesting to see how they prove that Lyra knew when he was getting paid that the money came out of here. Let's see which defendant Jane knew. This is the first time they've said Ponzi scheme. Otherwise, they just say scheme. Interesting that it comes up now, but okay. Defendant Jane and EJ Global and the partnership and Girardi Financial also knew that Girardi was operating a Ponzi scheme by breaching fiduciary duties to third parties and substantially assisting or encouraging. How, though? Like, that's just a legal conclusion. Like, when there's an answer to this complaint, the answer is going to be that's a legal conclusion that requires no answer. So through the course of 2018, 19, and 20, the Girardi firm made repeated representations that the settlement funds, the referral fee, while delayed, would be forthcoming. David Lyra spoke directly with Manuel H. Miller to assure him that the settlement and the fees would be paid. This sounds very much like what has been stated by others and by other allegations, that the lawyers in the firm, and this spells out Lyra specifically, were saying, no, it's coming. No, it's coming. What Lyra knew is going to be very interesting. On May 6, 2020, Tom Girardi wrote to Manuel Miller, I'm sure they have all of those communications, to state that the delay in paying the settlement and referral fee was caused by various tax issues pertinent to the litigation. That doesn't even make sense. Like, what tax issues? That doesn't even make sense. Because that's 3 years of time. That doesn't make sense. Additionally, Nicole Devonin, an attorney with the firm, which firm? I'm assuming Girardi Keys, because these are two law firms. An attorney with the firm advised that the checks for the settlement and the referral fee were on Girardi's desk waiting to be signed, and that, they'd be sent forthwith. This says nothing about what Erika knew and how she knew. They're going to need to have more information for this to continue, to go forward. This is making my head hurt. All right, aiding and abetting breach of fiduciary duty. I need to look if you can aid and abet the breach of fiduciary duty if you don't also owe a duty. I'm very curious. We know that Girardi had a fiduciary duty. Nobody's arguing that. And Lyra's actions, again, are a problem. But I don't see how Erika's actions, nothing they've said about Erika shows me that there's aiding and abetting a breach of fiduciary duty here. I'm sorry, it just doesn't. I need more. I need there to be more in here how she aided and abetted it. Lyra on the phone, if they can prove that Lyra knew, Lyra on the phone going, it's coming, the check's in the mail, blah, blah, blah. I can see that, but I don't know the rest of it. All right. Defendant's conduct was a substantial factor in causing harm to plaintiffs. Had defendant taken action to stop the tortious conduct and or refused to participate in, plaintiffs would not have been harmed. I mean, I don't doubt that if they had been notified much earlier that there was a problem, they could have done something to potentially remedy it. Plaintiffs were harmed in a way that they were deprived of the amounts they were owed for the services performed, but that's not what they're suing for. The Miller plaintiffs were deprived of $277,000, and Kathleen, as the representative, was deprived of $1.8 million. But it said they're not suing for that because that they have to go through the bankruptcy to get. So what additional harm was caused when they were deprived the amounts? And that's what I want to see. What additional damages were caused? I mean, they're alleging that they're there. I just need to see this. I am not. Okay. Financial elder abuse. Who is the elder? Because right now I'm not seeing where it says anyone was the elder. It restates the amount of fees. Both were older than 65 years of age at the time of the conduct, and that the action was reckless with oppression, fraud, or malice, which is interesting because if the theory is that the law firm's actions were because they were elder and that they were taken advantage of because they were elder, that's why they were able to put them off so much. But what I'm not seeing, and that theory may fly depending on what was said, what the emails were said, blah, blah, blah. But with that, what they don't allege is what additional damage was caused by not getting paid, increased fees, debts, those sorts of things, not being able to pay for medical, whatever it is. None of that's alleged here, and I would like to see that. Prayer for relief. And this again is asking for the amount of money they say they weren't paid. But in the introduction, okay, I complimented too early. In the introduction, it says plaintiffs are not seeking to recover funds misappropriated by Girardi or fraudulently transferred to defendants. Because that has to go in the bankruptcy. I think they're trying to get around the bankruptcy and they can't. Rather, plaintiffs are seeking to hold defendants liable for damage caused by their conduct, but they don't say what the damages are. The media made a lot out of this one. I don't know. This might be all bun, no burger. There's no real allegations about Erika. The stuff about Lyra is a problem, but it's going to continue to be a problem. But I don't know if that gets us out of the bankruptcy. Like, I don't know if this survives outside the bankruptcy because it's really, even though they say we're not seeking funds misappropriated, that's the amount of funds that they're seeking, and they don't show any other damage. Could this be amended? Yes. Am I like, ooh, here it is? Nope. There's no whoop. There it is. There's no there on this one. And I don't doubt that people were harmed by Girardi's actions. I really don't. But it's going to have to go through the bankruptcy. I appreciate the way that Illinois is going after the other lawyers. I want to know more about what the other lawyers knew in that firm. I want to know about whether the state bar is looking into what the other lawyers knew at that firm and how this went on for so fucking long with so many clients. I know it's easier to take shots at Erika. She's the one on television. It's expensive to be her, and she's the one patting the puss. But she wasn't the lawyer promising people that she would take care of them and then not doing it. She benefited from the money all day long, but the lawyers had a duty, and the lawyers were the one that promised they would take care of people and didn't. And it pisses me off, and it's never going to stop pissing me off. I want to know what other investigations are going on here. Let's get on to Jen Shah's fuckery. This one's not. There's not enough allegations here. There's not enough meat here. I don't know how far this will get. I hope that they are also making a claim in the bankruptcy court for what they did not get. but I don't know how far this lawsuit will get. For those of you in the chat that are like, I like the phrase all bun, no burger. That's not an Emily D. Baker original. I'm sure that is probably Hell's Kitchen or something. It is from some type of television show, I am sure. Shit out of the horse is one that, well, or toothpaste out of the tube, however you like to say it. I should stop talking about turn of phrases and just move on, because it's like an hour and 30 minutes in. Did I say to do the YouTubey things, the likey, subscribey things? I sure am close. We are sure close to 200,000. We sure are, and I'm very excited about it. If it is your first time here, most nights are not this heavy, and you can go ahead and do the likey, subscribey thing if it moves you. I would very much appreciate that, because I would love for us to hit 200K soon. But it's a slow month. And that's okay. February can be a time to like take a breath, reset. But go ahead and like do the likey, YouTube, subscribey things. Let's talk about, there's so much to talk about with Jen Shah. I don't even know where to start. Have you guys been enjoying this season of Real Housewives of Salt Lake City? For those of you that are watching Salt Lake City, go ahead and pop a 1 in the chat or a snowflake. For those of you not watching Salt Lake City, go ahead and put a 2 in the chat. Because some of you are like, I don't care about housewives at all. I just like their legal drama. That's completely fair. There is so much that is happening in the Jen Shah case. Emily, why? Well, it's getting ready to go to trial in March. So this is the time. This is the busy time where everything is going on. All the pretrial motions. A lot of you, I see a lot on the 1s and the 2s, on the snowflakes. So it's like we're split on those watching it and those not watching it. Some of you are like, I'm here for the legal fuckery. I'm just here for the legal nonsense. I'm going to give a brief background of this case, very, very brief. And then we're going to get into all of these pretrial motions, because there's so much to talk about. The Jen Shah of it all. Jen Shah is in like the 3rd round of prosecution of a very large telemarketing scheme. It is alleged that she is participating in it. Why do I not say alleged telemarketing scheme? Because like, I don't know, 20 plus people have pled guilty in this thing. Does pleading guilty mean it's a scheme? Yeah, yes. There's a scheme. People have pled. It's a thing. Large telemarketing scheme. Jen is alleged to be involved. In fact, the AUSAs have alleged that she is at the tip of the spear. She is one of the most culpable defendants. And she is now in the Shah-mazing position of being the last woman standing. She is the only person going to trial on this case. Everyone else has pled. So she is alone, which means a lot of them are going to come in and testify against her, I am sure, and say the things. But Jen is just, this is going to be an uphill battle for Jen Shah. And her lawyers are fighting it, but oh my. It's going to be very interesting to see in the reunion. I've seen the preview of the reunion was out today, or I think today is when it came out. Maybe it came out. I saw it today. Maybe it came out yesterday. And it was very much Jen Shah Andy being like, but like there's this case, and she's like, I don't know how much time I'm facing. I don't know this. I don't know that. Oh my. So we're in the pre-trial litigation phase. We are in the jury. They've submitted jury instructions, which we will do a different day. They've submitted voir dire questions. I like voir dire, so that's what I go with. They have submitted voir dire questions, which are very insightful. Then they submitted their proposed motions in limine. We've talked about the motions in limine before. No, they're motions in limine. Limited motions. We law nerds call them motions in limine. Those are the motions to talk about what evidence might come in or might come out, and have the court decide these things as a matter of law before the jury trial starts. Very appropriate. It is the thing to do. We're going to look at some of these proposed voir dire questions, and this is what the sides want to ask the juries or the panel, the veneer of juries before they sit on the jury. There can be objections to these and back and forth, but it gives us some very interesting insight into what the lawyers think will come up in the trial. So let me just explain voir dire a little bit. Voir dire, I had a DA friend who called it picky, guessy, choosy. And it always made me giggle. She's like, time for picky, guessy, choosy. Because really you are guessing as you are picking a jury, and you ask them questions and you try to understand where they're at, and you try to see if they might be able to sit and listen to your case without a bias or prejudice that would make it very hard for them to honestly sit in a case. I had a DUI trial I was doing. I did a lot of DUI trials, but I had a DUI trial I was doing that I felt very, very strongly about. I was a new DA. I felt very strongly about a lot of things. I felt very strongly about it because it would have been a third time DUI within a close period of time. And I was worried. Well, DA Emily is like, well, I'm worried if we keep doing the drinking, driving things that we're going to have problems and hurt people. So we ended up with a juror who very much didn't like the police. And that's not uncommon to end up with jurors who very much don't like the police. And this juror was like, I do not like this police agency, the police agency in my case. I think they pull over way too many people for DUI. I think they exaggerate their DUIs. And I think that they can never be fair, ever. And so I was like, well, then you are not a juror who can sit on my case. Then fuckery ensued with a particular judge that I do not have anything nice to say about, so I will not say it on the internet, but it became a total S show. The judge would not excuse the juror, would not allow me to use peremptories. The jury hung 11-1. Guess who didn't convict? Yeah, the juror was like, I hate this police department. I think they're all fucked up. I think they falsely accuse all of the people. And I'm like, okay. So I was livid. But you get jurors who are like, I cannot. I have these feelings. Good, have your feelings. This is not the right case for you. So that is what Wadier is trying to get to. But we get a heads up at what the attorneys think that they need to know about the what they need to know about for the evidence that's coming up. So it gives you a good preview of what the lawyers think the evidence will show to try to ask the jurors, can you be fair here? Because what you need is a jury that can keep an open mind. That's what you need. And that's all that you are looking for. A jury that can keep an open mind. So this is Jen Shah's proposed jury instructions. We're not going to get through some of the standard jury instructions. We're just going to get through some of the ones that give us insight into what might come up in this trial because it's fascinating. And Jen Shah is charged with conspiring to commit wire fraud through a telemarketing scheme and conspiracy to commit money laundering. Do any of you believe that Ms. Shah must be guilty of something because she has been charged in this case? This is a standard voir dire question. Not surprised. That gets into the rest of the standard questions. Some people believe that the government never arrests an innocent person in a criminal case. Do you believe that to be true? These are very, the early ones, very basic what are questions. Very, very basic. Would you hold the testimony of a law enforcement professional in higher esteem simply because of their profession? The prosecution's probably going to want to say, do you disbelieve anything that law enforcement says? Because that comes up on the other side. Have you had a negative experience with law enforcement or the government? Have you been falsely accused of a crime? Shah is presumed innocent, and the government has the burden of proving each element of the charged offense beyond a reasonable doubt. Do any of you feel that there may be cases in which it is appropriate to find that the government has not proven its case beyond a reasonable doubt? Like, are you comfortable voting not guilty? Shah has no obligation to testify. Will you hold that against them? Some people do. I appreciate it when they're honest about it. It's like, well, if you're innocent, why wouldn't you testify? It's like, because you have a constitutional right not to. Do you believe the Constitution affords too many protections to criminal defendants? Do you have a greater fear of letting a guilty person go than convicting an innocent person, et cetera, et cetera? Let's see. Some government witnesses have admitted to being involved in the crime charged here. So they think the co-defendants are going to testify. They will be testifying pursuant to cooperation agreements with the government. I wonder if the court will strike that. They might not. Do any of you believe such a witness might have a motive to testify falsely? That'll probably get stricken. This question will probably get stricken by the court. Would any of you assume that such a witness would necessarily tell the truth under oath? Because that's the way that it's asked is going to be changed. But getting to the fact that there will be witnesses who have taken a deal and they are testifying against Jen Shah. How do you feel about that? That's going to get reworded so it's not quite so like, but don't you think they can lie? Don't you think they should lie? Look, they're lying, because that could put into the jury's mind doubt that needs to be brought up in their case if it's appropriate to do so. Some government witnesses have pled guilty to committing crimes. Will you hold it against Ms. Shah that she associated with people who were committing crimes? So this is acknowledging the association, because they're not going to be able to get around it, because those co-defendants are all, well, not all, but a number of those co-defendants are going to testify. The government in this case has alleged that Ms. Shah participated in a fraud committed through telemarketing. Do any of you believe that telemarketing itself is a dishonest business? Would your opinions about telemarketing influence your view? Do you think all telemarketers are fraudulent? Because we can't have you on our jury if you do. Would your opinions about telemarketing influence your views? The government alleges that defendants targeted older people as part of their fraud. Have any of you felt that you or members of your families have been targeted for fraud because of your age? That's a very fair question. Ms. Shah's family, I don't know if this will stay in. Ms. Shah's family is from the island of Tonga and was converted to the Mormon religion by missionaries. Do any of you have negative opinions about Mormonism or those who convert to Mormonism? I don't know if that'll stay in. You will hear it, because I don't know if stuff about Ms. Shah's family is going to come up. You will hear evidence that when Ms. Shah married her husband, and this is interesting, how is this evidence going to come in is my question. And who does the defense intend to call, and how would this be relevant? That's what I'm curious about. You will hear evidence that when Ms. Shah married her husband, she converted to Islam, which is his religion. Do any of you have negative opinions or feelings about Muslims that would influence your view of Ms. Shah and her family, or the evidence in this case? It will be very interesting to me how this comes up. And as we watch this trial go down in March, we will revisit these questions and see what does come up in this trial, because I'm curious how this comes up. You'll hear evidence that Ms. Shah appears on one of the housewives in the television show on Bravo called The Real Housewives of Salt Lake City. Have any of you seen any episode of The Real Housewives of Salt Lake City, or part of any episode? Which one did you see? Was it when Jen Shah was drunk screaming grandpa fucker at somebody? Did you see that on television? Because that shit happened on television. Does anyone in your household or family watch The Real Housewives of Salt Lake City? Do you or anyone in your household belong to any fan group or online group which discusses The Real Housewives of Salt Lake City? Hi, we discuss The Real Housewives of Salt Lake City. We cannot be jurors. Do you or anyone in your household follow any account related to The Real Housewives of Salt Lake City on any social media platform? All of you are disqualified. I'm so sorry. I'm so sorry. I'm so sorry. Law nerds, you cannot be jurors. That's not true. You might be able to, but this question's going to come up and you're going to be like, actually, maybe. Have you read about Jen Shah and the show The Real Housewives of Salt Lake City? Do you know that Jen Shah was on The Real Housewives of Salt Lake City? Well, you just told me. Did you know that Jen Shah was on the show? You just told me. Are any of you fans of The Real Housewives shows? Would your opinion of the show and people who appear on the show influence your view of Jen Shah? All shows? If you have never seen any of the Real Housewives shows, do you have preconceived ideas about what kind of people appear on the show? And would those ideas influence you? Do you believe that all housewives who appear on the franchise are rich? It's a very interesting question. Do you believe that what you see on the show is in fact real? I'm going to be so curious about how this plays out, because there are motions to keep parts of the show out of the show. And with that, I think this question is trying to give the jury the idea that what you see on TV is not real, and what you see on these shows is not real. So almost putting the idea out there that any clips that might be played by the government aren't real. And that's going to be very interesting to me. Have any of you seen the ABC News special, The Housewife and the Shah Shocker, which is streaming on the Hulu platform? Look! We talked about it. And when this motion went down, that like the whole case needed to be dismissed because of ABC. And the court was like, and I was like, you can voir dire it. So here it is in voir dire. Were any of you in any way involved in the ABC News special? Well, if you call it Hulu there and call it ABC News here, how do they know it's the same one? Do any of you regularly read the following publications? Page 6, Us Weekly, People Magazine, or the Daily Mail? There's so many that they've left out. There's so many. There's so many that have been left out. And everybody's like, no. Why aren't we asking about like Andy's serious show? Like there's so many other things. Anyway, do any of you have strong opinions about people that participate in reality television shows? Do any of you think that what happens on reality television is actually real? That's the second time they're trying to get to that question, which again leads me to believe that the government is going to be using Jen Shah's words on the show against her, because in this season, you've got Jen Shah talking about Stuart Smith working for her, and he's like, she's trying to shove a banana in his mouth. This is all going to sound insane to anyone that doesn't watch this show. I am sorry. But she's like trying to shove a banana in his mouth while he's working on a laptop, and she's like, yeah, make me that money. And it's like, what? It's not going to go well for her. There's a lot of times this season where I'm like, that's not going to go well for her, including her talking to her lawyer about like, aren't Stuart and I on the same side? No, Stuart took a plea deal. He's going to testify against you. It's going to be a real awkward day in court when she's sitting there and he's sitting. I shouldn't have brought that document up. When she's sitting at counsel table and he's on the witness stand, it is going to be a real interesting day or days in court. Let's see. Would you automatically believe the opinion of an expert witness? And this gets into a couple different expert witnesses. I'm sure they're going to have experts with financial documents and how they got to financial documents and all that. Are you worried about serving on a jury during a pandemic? Very fair question. Would you hold it against Ms. Shah if this trial was impacted by COVID in any way? If you become a juror on this case, can you promise not to watch The Real Housewives of Salt Lake City? Like, don't go do research. The ABC special about Ms. Shah or any other media, online or otherwise, about Ms. Shah while the trial is pending. I'm sorry, jurors, you cannot watch if you are on the jury until it is done. Are you comfortable being part of a trial which will get a lot of media attention? Will you hold it against Ms. Shah if reporters outside the courthouse attempt to speak with you or contact you? Which again, reporters look. Until the trial is over, leave the jury the fuck alone. That's all. Just leave the jury the fuck alone. We're not going to get into jury instructions until another day. Why? Because we don't need to. I'm going to go to the proposed voir dire of the government because we're doing voir dire questions, and then we'll get into the motions in Lemonade real quick. We're gonna skim through them. We will get into the jury instructions later. It's just not needed today. The charges. I love that they've written out like exactly what they're going to read, because this is exactly how this is going to go in court. This is a criminal case. The defendant, Jennifer Shah, has been charged in an indictment with violating federal laws related to wire fraud conspiracy and money laundering conspiracy. The indictment is not evidence. It simply contains the charges that the government must prove to a jury beyond a reasonable doubt. I will summarize the charges in the case to determine whether there is anything about the nature of the case that may make it difficult or inappropriate for any of you to serve on the jury. The indictment contains one count related to wire fraud conspiracy and one count related to money laundering conspiracy. Count 1 charges that the defendant participated in a telemarketing fraud scheme from 2012 until 2021 that used fraudulent sales practices to sell so-called business opportunity products to victims, many of whom were elderly. Count 2 charges that the defendant participated in a money laundering scheme from 2012 until 2019, and that the defendant and other members of the scheme made certain financial transactions to conceal the proceeds of the telemarketing fraud scheme and avoid transaction reporting requirements. So that is what will get read, or that's what they're proposing will get read to the jury. Like, hey, this is what it is. This is what the judge will read. And then it will be like, can you sit on this jury? And so hopefully the judge will be like, fascinating. Do any of you believe you have personal knowledge of the case that I have just described? They're going to be like, I know Jen Shah. I watched The Real Housewives. Yeet me immediately. And I also hope that jurors don't use the I know who Jen Shah is from TV to get yeeted off this jury just because they don't want to be on jury duty, because this would be fascinating to be on jury duty. But also with financial fraud, especially with telemarketing fraud that involves people who are older, it is going to be hard to find jurors who have not had that experience and being like, no, this has been a problem in my family. So I can't listen to this because fuck those people. You can't have those people on the jury. Has any of you seen, read, or heard anything about this case? If yes, the government would respectfully request that the court follow up at sidebar, because here's why. They don't want the jurors to taint the rest of the jury by being like, yeah, so in season 1, Jen did this and this and this and this. And then in season 2, Jen did all this. And then there was this Hulu documentary, and then the Jen Shah and the Shaw Shocker. And then there's like podcasts and Twitter and feuds. They don't want that juror's answer to literally taint the rest of the jury to the point where they've now heard things and they all need to be excused. From whom did you hear about the case? Me. What did you hear, read, or see based on anything you've heard, read, or seen? Did it, have you formed opinions, et cetera, et cetera? Nature of the charges. And this gets into, can you be impartial with regard to the nature of the charges? And it will get into all of the, have you or a member of your family or close friends ever started or run your own business? If yes, what type of business? When did the business operate? How many employees did you have? Did the business have a website? Was it a primarily web-based business? Is there anything about that experience that would make it difficult for you to be fair and impartial? MLM questions. Look. Have you or any member of your family or any of your close friends ever participated in a multi-level marketing program or business? For example, Mary Kay, Avon, Youngevity, Herbalife, Amway, LuLaRoe, Rodan & Fields, New Skin, or doTERRA. Interesting. Why? Why do you want to know if the jurors had participated in an MLM? That's so interesting. I'm curious the thought process behind this and what the government wants to know. I wonder, here, we're going to speculate for a minute. Like, why would the prosecution want to know this? And I'm wondering if the prosecution wants to know this because they worry that people who are either in MLMs or had been MLMs might defend or feel defensive of the way Jen ran her business and be like, no, but that's how MLMs run too. It's fine. I'm curious if that's the thought process behind that. So they ask about MLMs, and then they ask what type of business, for how long, what was your role? Did you make a profit? Was it a web-based business? Interesting. Where have you had anyone in your family, or have you been a telemarketer or phone-based salesperson? All the same questions. Have you or any family member had any experiences directly or indirectly with wire fraud or money laundering conspiracies, including telemarketing fraud schemes, either as a victim, witness, subject of investigation, defendant? Knowledge of the trial participants. As I mentioned previously, the defendant in this case is Jennifer Shah. Please ask the defendant to stand. I love that we get the stage notes too. Do any of you know or have any dealings with, directly or indirectly, the defendant? Do you know that person down there? Before today, have you read anything about it? The defendant has been a cast member on the reality television show, The Real Housewives of Salt Lake City. Have you seen, read, or heard about it? Is there anything that you've seen, read, or heard that might make it difficult for you to be a juror in this case? Yeah, I've watched all of it. I cannot be impartial. The defendant is represented by, and then it gives the whole defense team. Do you know any of these individuals? The government's represented by, and then they give all the government team. Do you know any of these people? It's so interesting because there's times when I've had like witnesses or police officers, and jurors have been like, oh, that's my neighbor. And that's why you ask them to stand. Because sometimes, especially with agents, they go by their full name at work, but they don't always go by that name. Like their neighbor might be like, "Oh no, that's Tommy." But they don't think that that's Anthony at work or whatever it is, Tony, whatever. And you have them stand up and they're like, "Oh, I know that I know that person." So, always interesting to see what happens there. I will now read a list of names, and then this is all the key witnesses, and they'll read that all out. Relationship with the government is like, do you hate law enforcement? Can you be fair to law enforcement? Do you have a bias against these departments, et cetera, et cetera? Prior jury service, experience as a witness, defendant, or crime victim. They always ask people. These are kind of our basic voir dire questions. I'm trying to get to the ones that are new, different, or unique, like the MLM question, which I find fascinating. Let's see. Views on certain witnesses and investigative techniques. Would you be more inclined or less inclined to believe a witness solely because they were HSI or a special agent? So getting to those biases either for or against law enforcement, because again, it's trying to find an impartial jury. The government doesn't want to just pick a jury that's like, I listen to everything law enforcement says, because that can be a problem on appeal too. They want to find people who are like, I want to evaluate everyone on their own. And that's really what people are looking for. Ability to sit as a juror. Can you be here? Can you do this? Can you understand this? This is a publicity trial. Are you okay with that? Can you follow the instruction to not go read about this case on the media, social media, Twitter, blah, blah, blah. Function of the court and jury, which is going to be to instruct them about what their job is, probing at other biases, like, is there another reason you can't be here? Getting into the juror's background. These are all standard questions. Television programs or radio programs. No, you need to look, government. You need to start adding in podcasts. You need to know what podcasts people listen to. Look, people don't regularly listen to the radio. You need to ask about podcasts, because if you ask me what radio do you listen to, I'd be like, none. What TV shows do you regularly listen to? But I listen to podcasts, and you want to know what podcasts people listen to. Hobbies and leisure time activities, served in the military, member of any clubs or organizations, requested instruction following the impaneling of the jury. We got to that, and that's it. Where's the rest of our voir dire questions? Are they over here? Request to charge. Let's see. No. These are the jury, and those are the jury instructions. So that's the end of the voir dire from the government. Interesting, because they don't get into much more specifics. The defense gets into much more specifics. So that's interesting. All right, no, these are Jen Shah's proposed jury instructions. We don't need those. Government's motions in lemonade. Let's talk about these real quick. I know it's almost 2 hours, and then we'll get to a few of Jen Shah's objections. We're not going to do, this is a preview. We're not going to get into the deep dive. William, we don't talk about it. We're glad. We're going to let him stay there as a happy little fluff ball. He looks like a cinnamon roll back there. So the government is looking to admit evidence in a variety of categories, including the disposition of criminal proceeds. So where the money went, we're going to look at that. Defendant's financial circumstances, defendant's failure to disclose income to the IRS. That's going to go directly to money laundering. The argument that victims of the defendant's scheme to defraud are to blame for having acted negligently or gullibly. So it's trying to preclude Jen Shah from saying, well, they should have known better, and essentially saying that they're at fault for not asking better questions. The court should preclude evidence concerning potential punishment or consequences. That is a no. That's a non-starter, because it's just, that is just how the law is. You don't get to be like, but think of the jail time, blah, 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 blah. So, yeah. What else? The court should preclude evidence, potential punishment. The court should preclude evidence concerning defendant's prior commission of good acts or failure to commit other bad acts. Like, look, but she's never committed anything wrong in her life. Court should preclude evidence and argument concerning the government's motives, any claims, selective prosecution, any suggestion that defendant's conduct should have been handled as a civil matter, because that's come up in other ways. That the court should preclude evidence and argument concerning the defendant's family, background, children, race, health, age, religion, or other personal factors unconnected to guilt. And it'll be interesting, because it seems like from the voir dire questions that Jen Shah's lawyers want to get into how she met her husband and converted to his religion, and it's very, very interesting to me that that was in their voir dire questions. It might get yeeted out of their voir dire questions, but that it's coming up in this too. I wonder what the government suspects that the defense is going to bring up, and let's get into what they are trying to admit. So again, motions in limine are the motions asking the court to make some evidentiary decisions before the case goes to trial. Hey, you could admit this, you can't admit this. This may become admissible down the line. We covered this in other trials, including the Duggar trial. And we talked about this in the Rittenhouse case because there were things that the prosecution got into that had been denied to them in pretrial motions, and they still brought it up, which is a giant screaming fucking no-go. If the judge rules something in their preliminary rulings and the motions in limine, you can't get into it. And if you think you can get into it because the door's been opened, you have to talk to the court about that off the record, not in front of the jury. Big. So the trial is scheduled for March 22nd. The government moves in limine to admit evidence regarding all of the things we just talked about, or block some of the things we talked about. On March 25th, 2021, a grand jury, this is just the background. We know this. The grand jury returned the superseding indictment of Jen Shah. She was arrested, blah, blah, blah. Argument. The court should admit evidence regarding the disposition of criminal proceeds. How did the money get spent? Where did the money go? Where did the money go? The government intends to show the defendant exercised control over the disposition of the criminal proceeds of the telemarketing fraud scheme. So their argument's going to be, Jen, if you were taking the money, you had control over the business. You weren't just a passive bystander. The government intends to show such control by establishing that the defendant, among other things, engaged in transactions using the fraud proceeds and spent and directed others to spend criminal proceeds on expenses related to the telemarketing fraud scheme and her own personal expenses. They intend to offer evidence in the form of financial records, summary charts, and limited testimony regarding those records charts, as well as testimony by recipient witnesses, her co-defendants, Stuart Smith, with knowledge, that's my assumption, that recipient witnesses are her co-defendants because they're in the best position to say what she did because they were there. To the knowledge of defendant's disposition of the criminal proceeds, the method and manner in which the proceeds were directed, transferred, and spent by the defendant and her co-conspirators is admissible as direct evidence of defendant's participation. I don't disagree. We're not getting through the applicable law. I don't think it's helpful or relevant, and B, I don't disagree. She's going to say, I wasn't involved. And then they're going to say, but you had the monies. So if you weren't involved, why were you spending the monies? So that's going to be, I think, admitted. Let's see. They're getting into the reason it should be admitted. And I'm just going to go through their summary because their summary is quite good and we're doing a summary anyway. And I think that's all for our purposes today, all we really need. Evidence regarding the way in which defendants spent the proceeds of their scheme, first of all. But this is quoting the law, and the law is generally written in the male pronoun. Proceeds of his scheme to defraud is directly relevant, highly probative, and not unfairly prejudicial. It should be admitted as direct evidence of defendant's participation in the scheme and money laundering, proof that the defendant controlled the disposition of the fraud proceeds and engaged in money laundering, and evidence of the defendant's motive and intent to commit the crimes, right? Spending money on herself. And then they go through that the money is going to be traced. Evidence tracing the funds is proof that the defendant participated in the wire fraud conspiracy. It's the best part of it. Follow the money. Show them where the money went. How did the money get spent? What were you doing with the money? Just follow the money. Just in fraud cases, just follow the money. And if you don't follow the money, the jury's going to be like, well, what the fuck were you defrauding for? Where's the money? The jury only wants to know about money. So this is going to get admitted. It has to be admitted. It's going to be the heart of their case. Money, money, money. Money, 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 money. Money, the heart of any good fraud case. The defendant and her co-conspirators obtained the victim's money by, among other things, operating the telemarketing scheme. From there, they say the defendant and her co-conspirators engaged in numerous financial transactions, some of which concluded with funds being deposited into defendant's personal accounts. Weird. And others which involved expenditures from the business accounts for her benefit. The government should be permitted to prove that. Second, financial transactions and use of crime proceeds is essential evidence of the defendant's participation in a money laundering scheme. Yes, you can't money launder without money. And the government has to prove that. This is a non-issue, really. The court should admit evidence regarding defendant's financial circumstances. This is much more interesting. Relevant facts. The government expects that the evidence at trial will show that at least for certain periods of time during her charged conduct, the defendant was spending far more than she could afford absent the income from her telemarketing fraud scheme. So I imagine they're going to be like, okay, Coach Shah made this much money. She was spending this much money. That money came from this fraud scheme. The government intends for the evidence to show the defendant's financial difficulties and cash flow for the relevant time periods to be presented through documentary evidence and testimony, including, among other things, the defendant and her husband's income as reported to the IRS. I should have just kept reading. Her account balances as reflected on bank statements, her and her telemarketing company's credit and debit card statements, summary witness testimony regarding certain of the aforementioned records. And then they get into the laws. Why? Look, follow the money. Percipient witness testimony that defendant's income, need for money, and spending habits. Yeah. The spending habits will be the interesting one. But this goes to motive. Like, why would you be stealing this money? Well, you're spending a lot of money. That's why. The defendant's need for money during certain times of the offense conduct is highly probative of her motive to engage in the charged conduct. Like, why would you put all this at risk? Well, the defendant's spending habits and need to finance her expensive lifestyle. I'm sorry, I believe that's spelled with a $sign and multiple X's. Maybe I'm wrong. It's expensive to be Jen Shah. She doesn't even have a song. She can borrow Erika Jane's song. It's expensive to be her too. To finance her expensive lifestyle, provide necessary context for the defendant's conduct, which would appropriately be viewed as shockingly brazen. Don't get brazen with me. Shockingly brazen. Shaw shocking? Is it Shaw shockingly brazen? And it is an important factor that the jury should be permitted to consider in assessing the defendant's intent. For the same reasons, the courts routinely admit such evidence. Yes, they do, especially in this type of case. In short, the defendant's spending habits and need for money at particular points in time during the charged conduct are an inextricable part of the story of the charged offenses. You guys are like, shockingly is misspelled. It is. Shockingly brazen. Thank you, Del, for spelling shockingly properly. I clicked that too fast. As discussed above, an explanation of why the defendant would engage in the charged conduct becomes highly relevant when the defendant argues they did not commit the crime. The court should admit evidence of defendant's failure to disclose income to the IRS. Here's the interesting thing. Will have to be, can the jury parse that as saying, okay, it's not that we're going to hold you responsible for the failure to disclose to the IRS, but that's evidence that you knew the proceeds weren't proper, that they were illicit funds. The government seeks to admit evidence that for the time period relevant, the defendant failed to disclose income from the fraud scheme to the IRS. I bet the IRS would love to know about that because even if it's for fraudulent, the IRS, oh man, won't it be interesting if for some reason this doesn't go to trial, or if for some reason Jen Shah doesn't get convicted, or if, won't it be interesting if the IRS is like, well, actually, we also have some questions. And then she ends up having them come back for a second bite at the apple, because failure to pay the IRS is completely different than the money laundering and fraud scheme. It's a completely different thing. She could get convicted for this and then still have the IRS come back around for its piece if they prove all this and are like, she didn't pay and here's all of it, it could come right back round to, oh, and by the way, let's talk about the tax evasion of it all, if that is the case. The government seeks to admit evidence that she didn't report income to the IRS. The law says you can do that. Discussion: the government seeks to admit evidence that the defendant failed to disclose income from the telemarketing fraud scheme for the time period in which she participated in the charged wire fraud and money laundering. This evidence is direct evidence of the charged crimes. And in the alternative, pursuant to 404B, we've talked a lot about 404, which shows the motive, the opportunity, the et cetera, et cetera. Defendant's failure to report income provides direct evidence that defendant understood that this money was not legitimate income for her. This evidence, therefore, provides direct proof of the defendant's intent to defraud. I mean, unless she testifies that she just really wanted to commit tax fraud. Could you imagine? It's like, no, it's not that I thought the proceeds were illegal. It's that I really just didn't want to pay taxes on it. In an alternate universe, I'm teasing. But the IRS will find theirs. Trust. If you trust nothing else, trust that. Moreover, the evidence is relevant and critical to rebutting any expected defenses, namely that the defendant thought her telemarketing business. This is a really important point, and my brain cannot make words happen. Rebutting any defenses, particularly that the defendant thought her business was legitimate and therefore was entitled to the money that she earned from the transactions. That is a very good point for the government. If she believed that this was like business, I'm just a business genius, business, then why aren't you reporting it to the IRS? Is it because you thought it was fraudulent or because you like to evade taxes? Either way, you're kind of fucked. If they prove this, because these are their allegations and their motions, and well, they're not allegations, they're their recitation of the facts that they're alleging in these motions in limine. But it puts Jen Shah in a really tough position on defense, where she has to decide if she addresses that, if she doesn't, and it puts her in a corner if she does testify, which I still think she could testify or could choose to testify. She can always testify. She has that right to testify or not, but I still think that she might. So, very, very interesting, but they make a good point that if it's legit, why not report it? In the alternative, the records are admissible pursuant to 404 as they are highly probative of the intent, plan. When I said blah, 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 these are the other parts. Blah, blah, blah. Intent, plan, knowledge, absence of mistake or accident. Absence of mistake is a big one. The tax records demonstrate, among other things, that the defendant knew that the income she derived from her participation in the telemarketing fraud scheme was illegitimate and sought to conceal it. The defense will have a hard time arguing around that. It's like, no, you know how taxes are. Like, these rich people and their taxes, they don't really pay them. It's not really tax evasion, but it doesn't mean she thought it was illegitimate. I can see that all happening. So they're arguing that it can be 404B evidence. Let's see. The court should preclude evidence and argument that the victims of the defendant's scheme to defraud are to blame. So we would like to stop the victim blaming before it happens, please. That the victims acted negligently or gullibly, which does come up in fraud cases all the time. So the federal fraud statutes, including wire fraud, do not require the government to prove reliance on the defendant's conduct as an element of the offense. The defendant should therefore be precluded from suggesting during the trial, whether in jury address or witness examinations, that the victims of defendant's fraud are to blame, either because they failed to conduct sufficient diligence, were negligent, or otherwise acted unreasonably in relying on the misrepresentations made by the participants in the scheme. Which is a big distinction. They're saying we don't have to prove that the fraud is what was relied upon by the victims. They get into the applicable law under Rule 402 and talk about the law with regard to the scheme and say that it's irrelevant. So they're seeking to preclude the defense from even getting into it. And I think that that's appropriate. And I don't think that will be a problem, but we'll see what the court says. They're saying as part of a telemarketing fraud scheme, the defendant and her co-conspirators lied or caused misleading information to be conveyed to the victims. The diligence and sophistication of those the defendant and her co-conspirator targeted during the scheme to defraud are not appropriate considerations at trial. The court should preclude evidence and argument concerning the potential punishment and consequences. That is just not allowed to come in at all. So it shouldn't come in. It's not like, but is this really worth going to prison over? Like that kind of stuff can't come in. It's not the jury's to decide. They're not allowed to consider punishment because punishment can be anything. There's no minimum sentence. Unlike the Duggar case where there's a minimum prison sentence, there's a floor. It's like you've got to go to prison for this amount of time. There's no floor here. It could be probation. So they can't argue to the jurors. The jurors never should consider punishment. But they're also, the government's making their record. Good acts like what she's I don't know what just happened there, but that was weird. Good acts like, oh, she's never been in trouble before, that kind of stuff. If she testifies, though, that can become relevant. So they might not be able to block it forever. They might be able to block it unless she testifies. If she testifies, it all becomes relevant, and then some of that can come in. Evidence argument concerning the government's motives. Any claim of selective prosecution suggested that defendant's conduct should be handled as a civil matter. That generally shouldn't come up. So we'll circle back. I want to see what the defense says on these more than I want to see what the government says on these, because the government's trying to block these. I want to see what the defense says, if they're trying to get them in or not. Should preclude evidence regarding like the defendant's family, kids, race, health, age, religion, or other personal factors. I'm curious what the government thinks she's going to try to introduce. The defendant should be precluded from offering evidence and argument concerning her family background. I mean, if she testifies, though, that might come up, and they don't really get into it other than saying it's irrelevant. If she testifies, it becomes much more relevant, which is part of the determination of whether she testifies or not, is how she best makes herself sympathetic to the jury. Part of that's by testifying. So let's see. Let's see. The government's proposed examination of prospective jurors. We did that. Government's request to charge. We did that. Let's see. Proposed verdict forms. We did that. Let's go to Jen Shah's motions that were just filed. Let's see. Oh, these are the government's objections to voir dire. Since we just talked about that, let's talk about that right now. The government respectfully submits this letter to object to 3 questions listed in defendant's proposed examination of jurors. Question 16. The government in this case alleges that defendants targeted older people as part of their fraud. This contains at least 2 flaws. First, the defendant seeks inappropriately to raise the government's burden. The government alleged in the superseding indictment that defendant participated in a conspiracy to commit wire fraud. Oh, hey, Fred. That victimized 10 or more persons over the age of 55. The superseding indictment does not, as defendant suggests, allege that the defendant targeted older people as a part of their fraud. So they have an issue with the way it was worded. I can understand why. That would probably be easy to reword. I don't imagine that the court would have a problem with rewording it, and the defense maybe shouldn't have an issue with rewording that either. Questions 17 and 18. These are the ones I talked about. The defendant proposes that the court educate potential jurors regarding the defendant's family's national origin, her prior religious beliefs, her current religious beliefs, her apparent conversion from one religion to another. This is entirely improper. We talked about that when we were just doing it. The government does not anticipate there being any evidence or argument at trial regarding these facts, nor should the court permit any such evidence to be argued. To be clear, the government does not intend to introduce any evidence or make any arguments regarding the defendant's family's national origin, her prior or current religious beliefs, her conversion from one religion to another, because among other reasons, there's no such conceivable relevance of any of these facts unless the defense seeks to bring it in, which will be very interesting if they do. So let us go to there were things Jen filed today. What day is today? The 18th filed yesterday. Apologies. Yesterday. The defendant's motions in eliminate. We're going to cruise through those real quick and then do a few questions. And then And then I'm going to yeet myself to bed. I'm going to hurl myself into I'll probably take a bath first, but then I'm going to hurl myself into the bed. Motions in limine. So they're saying that the government's 404B evidence should not be admitted. Evidence that did not disclose IRS certain income shouldn't be admitted. Evidence defendant failed to maintain records relating to foreign financial accounts. They didn't seek to admit that, so it's interesting that they're bringing that up. Evidence that in June 2018, the defendant directed Stuart Smith to lie during a Federal Trade Commission deposition. Yeah, so no. I'm glad we're here. I'm glad we're here. Evidence related to use of a credit card of Mastery Pro Group by defendant. Evidence that during the period of the indictment, the defendant threatened Smith and Smith's wife. What? During the period of the indictment, defendant threatened Stuart Smith and Stuart Smith's wife. What now? What now? I like that the defense motions have more tea because the government's not saying shit about this. They're going to bring all of this in because Stuart Smith is going to testify. I have to be in New York. I have to be in New York. If Jen knows this, her attorneys are putting this in these motions. Yeah, right, Fred? It's fucking crazy. I agree. Defendant opposes the use of any clips from the Real Housewives of Salt Lake City at trial or in the government's case in chief or for cross-examination. Fred, what? Fred's not. Do you hear him? Probably not. It's a directional mic. Fred is very vocal about what's going on here. He's like, how dare she? How dare she threatening people? The government should be precluded from introducing statements of alleged co-conspirators until the government establishes the scope of a single conspiracy. Let's see what happened. Let's get in case law, rules. Jen Shah would like these things excluded. I don't really care so much about some of the 404B stuff. It's not going to be totally relevant. But oh my God, the government's theory of the case is that Jen Shah was involved in a conspiracy to commit wire fraud through a telemarketing scheme that spanned 9 years from 2012 until at least March 2021. If y'all want the rundown on that, it's the other videos. We have a lot of them on this case, but it's let's see. It's the government's motions and the defense motions around the dry contact. It's those motions that really get into the heart of this scheme. But it's so interesting what the defense is trying to keep out is so interesting. Because here's why I'm just like, the defense trying to keep this stuff out indicates what is likely. This is my supposition from lawyerly things. This is my supposition. When Stuart Smith, well, no, this is known. When Stuart Smith changed his plea, he gave like a factual basis plea. He gave a proffer. Like, this is all the shit that I know. And then he said, he added a charge. Well, no, the government added a charge of perjury. So he pled to a perjury charge. The only reason that he would have pled to a perjury charge is so that information could come up in this trial because there is no criminal conduct pending. So Stuart Smith can't get on the stand and be like, Jen Shah made me perjure myself during a deposition with the SEC, because he would have to take the fifth, because then there would be potential criminal liability pending. His lawyers would be like, what you can't say is any of that. But because he's already pled, there is no pending criminal or potential for criminal behavior, or not criminal behavior, criminal consequence. So he can't plead the fifth. So whatever he gave in that proffer saying, these are all the things I can testify to, and this is what I know. And then they changed the indictment to add that perjury count. It allows them to testify about all of this. The defense knows what Stuart Smith said. So they know what testimony is coming from him, which is why we are seeing the defense try to block that from coming in, because of course they are, because that is their job. to try to block that from it's not going to work, but that is our job. But you guys know, I think Jen should have pled at the beginning of all of this. I don't know how this is going to go well for her, but she has the right to go to trial. She's innocent until the government proves it to a jury. They've proven it to other juries before because this is now the third group of this case going to trial, but okay. This one's not going to go well. Let's see. Ms. Shah's defense, great, is that while she worked in the telemarketing industry and worked with many of the people who are witnesses in this case against her, including Stuart Smith, she did not participate in the fraud. Business. This is not fraud. I did not participate in fraud. I did nothing fraudulent. I was running a telemarketing business. Only relevant evidence is admissible. Thank you. However, even if relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading a jury, or by considerations of undue delay, waste of time. Yes, we know. Undue delay is one of the things that had me yelling during one of the last trials we were covering. It's like, why do you keep asking this? Here are the objections below with the 404. We do not need some of this 404B evidence, is what they're arguing. The 404B should not be admitted, that Jen Shah did not disclose to the IRS. The government seeks to introduce evidence that Ms. Shah committed tax evasion during the period of the conspiracy and that the tax fraud involved income from her participation in the crimes charged. There's no dispute that Ms. Shah worked in telemarketing for many years and received income from her employment. The government has offered no details as to the alleged tax evasion. They're just saying she failed to report it. They're not necessarily saying it's tax evasion. Neither the timing of the alleged evasion nor its extent. Well, that should have been in discovery. I agree with them. I don't know if that's exactly what it is, but that should have been in the discovery. The issue of whether the government can prove that the funds that were the subject of the tax evasion came from the fraud. If they cannot, then this evidence would not be admissible. So they're saying that the whole business is a fraud, though. So the government's going to be like, everything you did at those companies was fraudulent. So if you weren't reporting your income, then that one's going to hinge on what the government shows and what the evidence shows. And they should have that. The defense should have that. So yeah, it'll be interesting. I will be interested to see what the court rules on that, because again, the defense raises a good point. You have to show that that's the same income, and that'll be interesting. Evidence that defendant failed to maintain records relating to foreign financial accounts. We heard nothing about that in the government's motions in limine. The government seeks to omit evidence from 2016 to 2021 that defendant failed to maintain certain records and file certain reports relating to financial accounts in a foreign country. Well, that's going to go to some of the money laundering, I imagine. And they're saying she was required to maintain them. And they're going to say she didn't maintain them because it was fraudulent. And she's going to say, what? Whoops. The government does not provide any information as to why this allegation is relevant to the prosecution here. Money laundering. Money laundering. Money laundering. See, the out-of-country accounts are relevant to the not reporting financial transactions, which is part of the money laundering conspiracy. And they're saying the government needs to prove that connection. And then they're saying that this is causing the defendant to defend against new accusations that would confuse the jury. The jury doesn't need to know whether she was required to keep the records or not. The jury needs to know whether she was reporting foreign transaction as part of the money laundering scheme, the alleged money laundering scheme. Evidence that in June 2018, defendant directed Stuart Smith to lie during a Federal Trade Commission deposition. Ooh, this is very short and I'm very sad. I want to know more. The government proposes to enter evidence that in June 2018, the defendant directed Stuart Smith to lie during an FTC deposition. Since the subject matter of this evidence has not been provided, it is difficult for the defense to respond. They don't have the FTC deposition because it was in some of the parts of it were in some of the filings. And I think parts of it, I need to go back and look. I think parts of it were also in the defense filings, the FTC deposition. They could have that transcript. But if it does not relate to a disputed issue at this case, it should be excluded as prejudicial. It's the same companies. We've talked about this on this channel. It's the same companies. Evidence of evidence of requesting that a business associate lie in a deposition is forbidden if its only probative value is to show the defendant's propensity for dishonesty. Oh no. No, it's to show that they were engaging in a scheme to defraud because it's related to the same companies. That would be my guess, but I liked fraud cases, so my brain kind of leans that direction. Evidence relating to the use of a credit card of Mastery Pro Group by the defendant. The government proposes to elicit evidence that during a period of the indictment, defendant used the credit card of Mastery Pro Group for personal expenses in violation of her agreement with Stuart Smith. Okay. And falsely claimed that the personal expenses she charged with the card were unauthorized purchases made by her assistant in New York City. The government has not indicated what justification there is for introducing this evidence. How do you know they want to introduce it? Is it in discovery? I'm confused. There's not enough context here for me to say one way or the other because the government didn't put any of this in their motions. Without additional explanation, this is, you know what? This is probably in Stuart Smith's stuff too because it's related to him. Without additional explanation, it would seem this is the kind of propensity evidence forbidden under 404B. I mean, the government might need to explain that more. The evidence will only paint the defendant in a bad light as someone who would use a business card for personal expenses or shows that she controls the companies. But if Stuart's testifying, then they can cross-examine him about it. Gosh, that'll be interesting. Evidence that during the period of the indictment, defendant threatened Smith and Smith's wife. Damn it, this is like 2 sentences long. I wanted more tea. Wah. The government will seek to admit evidence that the time of the indictment, which spans 9 years, quote, the defendant threatened Smith and Smith's wife. Without more detail, it is difficult to discuss this proffer of evidence since neither the subject matter content nor the timing is provided. Now, that's fair if that hasn't been provided. I want to hear the government's response. I'm very curious. Accordingly, the defense preserves the right to object. I very, very, very much want the government to lay all of this out in the reply because the defense has brought it up and then we might all know. And I want to know the things. Defendants oppose the use of any clips from Real Housewives of Salt Lake City. Ms. Shah is a resident of Salt Lake City. Great. Since 2020, Shah has been on the cast of RHOSLC. It's the longest one. It's so hard. The first episode of SLC was broadcast on November 11th, 2020. In season 1, which ran from November 11th, 2020 till February 17th, 2020, there were 18 episodes. God, it felt longer than that. Season 2 began airing February 9th. And as of February 6, 2022, there have been 17 episodes aired. Each episode's approximately 45 minutes. We know that it's reality TV, which is defined as TV made from ordinary people, quote, playing themselves on a TV show. Ooh, we're leaning into it's all fucking fake. I love it. The defense opposes the use of evidence of any clips of the show, any use of clips from the show at trial, either in the government's case in chief or during cross-examination of the defendant's case. If the defendant testifies, we don't want her confronted with clips from the show. Can you see it? But Miss Shah, did you really think that Mary was a grandpa fucker? Which wouldn't be relevant. It would never happen in court. It's not relevant. But some of the other things are, including the stuff from this season with her and Stuart. And that would be the stuff that would come up most, is the stuff with her and Stuart. The evidence would have to fall under one of the exceptions to the hearsay rule, as they are, by definition, out-of-court statements. Accurate. To evaluate whether the statements the government might seek falls under any exception, it's necessary to examine the method used to produce and edit the Housewives show, and also the motivations and contrivances that permeate the production of the Housewives franchise. Coming for Bravo. I see you coming for Bravo. As will clearly be shown, there are no circumstances under which a clip of Jen Shah from her appearance could be used in court, as these clips do not have any indicia of reliability, which is the fundamental principle underlying the hearsay exception and indeed the rules of evidence. Did you say this? Did you not say this? It's her words. Okay. For those unfamiliar with the Bravo franchise, well, thank you. Please educate me. It would be hard to overestimate its reach and popularity. Each Housewife series takes place in a different location. We know there are literally hundreds of episodes. Okay. Such is the popularity of the show that newspapers and other online outlets summarize the episodes of each show and post them for public consumption. I don't summarize them. We just talk about the lawsuits. Recently, a book was Dave. Is this Dave's book? Recently, a book was published about the Housewives franchise, which delves not only into the details of many of the individual shows and their characters, but also into how the show is produced. Wait. Oh, boo. They're not talking about Not All Diamonds and Rosé. Not a plug for Not All Diamonds and Rosé, but this book has the tea on how stuff is filmed and produced. I'm disappointed that it's not this one. It's still a good book, Dave. Characters. These aren't real people. Characters on the various Housewives franchise stand to make enormous sums of money if they are successful. First, as the show progresses from one season to the next, the per episode fee increases proportionally with for a character who's popular. Equally important for someone like Miss Shah, who is starting a fashion business. She was starting a fashion business. As her participation began, the show provides an invaluable advertising platform. Thus, all characters have an incentive to exaggerate their characters and dramatize their lives in order to participate in the currency of the Housewives franchise. Fine. It only becomes relevant if it's not relevant, it's not relevant. But if she said it, and she can be confronted with it. But if she testifies, but if she doesn't, okay. Let's see. The first hurdle for any contestant. Oh, they're contestants now. This is fascinating. We've gone from like a, peek behind the gates to Survivor. The first hurdle of any contestant, of course, is to be chosen as a housewife. The requirements for being chosen is that you have a job or a business and that you appear to have money. As Moylan stated, I love that they're quoting a Housewives book. We know that many of these women are playing at being rich. One has to appear to have money to get on the show, to make even more money, which then needs to be used to look like one has money. The persona of the women on each of the franchises is that they are glamorous, incredibly rich, live lives of extreme and conspicuous consumption, and are willing to reveal their personal lives in public. The Housewives shows have been described as a cross between soap opera and reality TV. Again, from this book. I love that it's like this is now in the legal pleadings I'm living. There has to be a storyline and a narrative to create drama and maintain the interest of viewers. Thus, the question arises, how fake or how real are the women and the lives portrayed on Housewives? I love that we're getting into a dissertation on reality TV right now. I'm living for all of it. The answer is, it wasn't a hypothetical. There's a footnote. Many articles have been written on the subject. 10 things the Real Housewives that are totally fake. I've never heard of thethings.com, but apparently the thing says things are fake. The answer is, the women in their lives are both real and fake. Are both real and fake. And it is impossible to tell where reality ends and fantasy and outright deception and fakery begins. I was really hoping that said fuckery, not fakery. The women, the housewives themselves, are real people. Well, I'm glad to know that they are not animatronic or holographic. Or actors, I suppose. Well, some of them are actors. Anyway, the basic facts of their lives are real. Are the days of their lives real? Their names, their husbands, their divorces, their time in rehab, their children. But the more pertinent questions, according to Moylan, are, we're just quoting the book entirely. How produced are these shows? How much of what you're seeing on TV is natural and spontaneous, and how much is crafted and manipulated? Well, if she's lying, then she can say she's lying. As Moylan puts it, When lives get turned into storylines, how much of it is reality, how much is for the camera, and how much is manipulated in post production? The answer is thank you for providing the answers. All of this is irrelevant to this motion, but I'm loving it. The answer is a great deal and probably much more than the average viewer imagines. The line between what is real and what is produced, manipulated, and made up is porous and hidden. Oh, how many pages is this going? Oh my God. We've got a whole end of semester paper on this. At the beginning of every season, every Housewives production, the producers interview each character and work up a storyline for the season. Can you imagine? So, are you getting divorced this year? How about kicking addiction? What's going on with your children? Did you build a new house? Okay. Okay. They work up a storyline for the season. Some of them are more or less real, a child going to college, and some are entirely made up, trying to have another baby. Oh my God. The shade, Melissa Gorga. The shade, Melissa Gorga. The shade. I know. You guys are in the chat going, did Teresa sit down and go, so how about going to prison this season? How's that feel? Federal prison. I'll take federal prison as my storyline. Or a sister wife. All of you are yelling, or a sister wife. I mean, the sister wife storyline seemed completely fucking contrived. You're absolutely right. Trying to have another baby. Oh. Or pretending to want to open a particular business. What fake businesses? Where? Then the producers create what is known as the show Bible, which is an actual document. We know what a show Bible is. We listen to the Office podcast. We listen to the Office ladies. They talk about the show Bible all the time. Oh my. Sorry, mods. I know we've gone long. I'm just fascinated and giggling. You guys give the mods some love as we go through this dissertation on Housewives through a book about Housewives. And the court is going to be like, what is happening? The producers create what is known as a show Bible, which is an actual document that, quote, literally outlines every woman, every storyline they have, and the direction that we, the producers, think they're going in. Okay. Andy C said book is bogus. No first person. I don't know how real this book is. Like, I have no idea. It's just very interesting. It's an illegal document. And I'm not surprised if the producers sit down and outline who the women are, what happened last season, what's going on in their lives, and then what might happen. Like, hey, this, so they can keep an eye on it as they go to editing. That doesn't shock me, but that doesn't mean it's contrived. But I'm sure some of it is, but I don't know if it's contrived by production or by the women, like trying to have another baby. As the season progresses, the producers guide the show to maintain a storyline for each character. It is important that the storyline is compelling in order to generate interest in each character's life and plot. That is the job of the housewife. In discussing the housewife's interest in maintaining and promoting their own storyline, Moylan said, couple that with the motivation and wanting to stay on this cash cow, the show, and that's a pretty healthy incentive to make sure that your storyline is fresh and the drama is flowing. But she wasn't faking that Stuart was her assistant, and a lot of the other shit's not relevant. I don't know why we're so deep down this rabbit hole right now, but I literally can't stop. I'm sorry. I can't. Oh, there's another footnote. Where'd that footnote come from? Oh, down here. Okay. The actual episodes of Housewives, those that are seen on TV, are highly edited. No shit. And crafted through post-production. Yes. This book, Not All Bravo and Rosé, which is actually put out by Andy Cohen Books, interviews the housewives and is by my friend Dave Quinn, who I adore, actually calls it the Bravo Wink is their production. But anyway, the average time it takes to edit an episode of Housewives is 10 to 12 weeks. One episode or one season? I would imagine that's a season, not an episode. During which time the crew is whittling more than 40 hours of footage into a 40-minute episode. That means there's little more than 1 minute of good material in each of the 40 hours of footage. Footnote 3. The book actually says it takes 40 hours of footage to get 45-minute shows, and that means that 1 minute of good material in each of the 40 hours, but this must be a mistake and is 1 minute per 4 hours. For our purposes, its impact on the reliability of what makes the final show is the same. Wait, the footnote says that the book's wrong? Wait. I have to read that. I have to read that again. The book actually says that it takes 40 hours of footage to get a 45-minute show, and that means 1 minute of good material for each of the 40 hours. But this must be a mistake, and it is 1 minute per 4 hours. I am so confused. For our purposes, its impact on the reliability of what makes the final show is the same. Y'all, which one's right? Is it, if it takes 40 hours to make a 45-minute show, isn't it 1 minute per hour, roughly? Because they're saying that's 1 minute per 4 hours. I think the lawyers are wrong. What do you think? I think the lawyers are wrong. I think the lawyers are wrong. I'm so fucking confused by this goddamn footnote right now, and I'm angry about it, and I can't let it go. I think the 1 minute per hour is right. Chat, help. Am I crazy? Is it late? I have been drinking kombucha. Like, thank God this wasn't a whiskey stream, or I'd be so fucking confused right now. But I need to know. Okay, I think it's 1 minute per hour. And yes, these are my monkeys. If you're in the footnote going, we think the book is wrong, why are you writing 5 pages in this motion about this book right now? Y'all are like 1.125 minutes per hour. Annie came in with the hardcore math. That's hard maths. Hard maths. I am also confusion. I am confusion. I am all of the confusion. Yes, 1 minute per hour. Around 1 minute an hour. Like a little over a minute an hour. The lawyer's math is wrong. Okay. And yes, lawyers are terrible at maths. Unless it comes to their legal fees. They're good at the money they are owed. But I love that they're quoting this book for how many fucking pages we've been on now. They're quoting this book for page after page after page, and they're like, but this must be a mistake. And it's 1 minute per 4 hour. But if it's 1 minute per 4 hours at 40 hours, wait, there's probably division involved. But that's only 10 hours. So that would only be 10 minutes. This footnote sucks. I hate it. Footnote 3. Fuck off. We're 3 hours into stream. We don't have time for your bullshit. Footnote 3. You are the worst. And I hate it so much. I was so excited. I was optimistic. I was rooting for you, footnote 3. We were all rooting for you, footnote 3. Anyway, going on to the fact that they get about 1 usable minute for every, hour of footage that they film. They say, and that's an estimate. They say, thus, any actual clip of the Housewives show is just a teeny portion of the footage that was shot, obviously. And an episode can turn a week of filming into just part of a day, obviously. One of the main procedures that producers use for editing an episode is what's known as a confessional. That's not a procedure, that's a part of filming. These are interviews that housewife characters, they're back to characters. They're not contestants anymore. We've flipped back to characters, not contestants. These are the interviews of housewife characters, or sometimes their kids. I love the kids. I'm loving Gia's confessionals. It's been great. Okay. The characters, not contestants, which take place after the shooting and when the producers have had a chance to see where there are gaps in the story and need more explanation. So these confessional portions are cut in after the scenes were shot and deliberately crafted to help the storylines and create additional drama and conflict. And there are other techniques used by Housewives editors like Frankenbites. I don't know how we got here in Emotion and Lemonade. I don't know how we ended up here. This is not the direction I thought this motion was heading in. I was just looking for them objecting. I have not had time to read all of this. This is a first look, which we shared. I have read the headlines like they don't want clips being used. I thought there would be more legal argument about why they don't want clips being used. I didn't know we were getting a whole ass dissertation based on someone's book, not this one, about the Housewives and how it's shot. And I'm loving that we're here. I just had no idea this was the direction we were going. I'm so confused. Frankenbites also sound like a Halloween dessert that you would see on Pinterest, right? Like green brownie bites or something. They feel like a Pinteresty kind of themed food. Let's see what a Frankenbite is described as. Oh my God, we need to make a Frankenbites recipe. If we ever do a live event, we need to have Frankenbites there. Let's see what Frankenbites are. Frankenbites, as defined by book, is, quote, the gruesome name given to a process where an editor splices words someone has said from different sources to make a sentence the person didn't say at all. So what they're saying is it's splicing together sentences? But if it's different sources, that doesn't make any sense. I'm so fucking confused. So Frankenbites is the gruesome name given to a process where an editor splices words someone said from different sources. I don't understand what they mean by sources, because if the person is the source, who's the source? What is the subject? I am so confused. But if the person said it in different contexts and then spliced it together, it's a problem. It's something like, she's a whore, she's fucked half of New York, I hate her. Like, I felt like that was a stream of consciousness thing. I don't think that was a Frankenbite, but it was just like, it has to be, or they have to be trying to get at, splices together different context or splices together the sentence so it gets chopped up to make a sentence a person didn't say at all. So it's trying to say, look, I think the point they're trying to get to, and I think you're right, different scenes, I think the point they're trying to get to is that, Your Honor, without the raw footage, you cannot use anything that Jen Shah said on the show, because we can't rely on the things that were said were actually the things that were said, and that each sentence wasn't super manipulated. I think that's what they're trying to say. Thus the characteristics of film clips which make it into the final episodes that are on TV, make them particularly unsuitable to be admitted under the rules of evidence. Here we go. We got back to the point. We've wound our way back to a point. First, there is a generalized motivation to exaggerate wealth and drama in order to remain on the show. Okay. The storylines of each character are manipulated by the producers. Okay, but the characters are well aware of the need for them to participate in this kind of drama to stay on the show. The editing process ensures that it is impossible to understand the actual context of any particular statement as it was drawn out of footage. 1 minute per 4 or 40 hours. We're still in the 4 or 40 hours that the viewers never see and have no way of knowing the context. Well, it doesn't matter what the viewers know. What the viewers know is irrelevant. It's whether she said it or not. And okay. Finally, all the footage has been edited with great care and can be subject to such techniques as Frankenbites. Oh, I can't wait to see the government's reply to all of this. I really hope they don't just say all of this is irrelevant. I hope there's a reply. I hope. I want to see what happens. Ah! No, Echo, cancel. You scared the shit out of me. What is wrong with you, Echo? Cancel. My Echo is Frankenbiting me right now. Frankenbite yourself, Echo. Good Lord. Scared the crap out of me. Echo's trying to read my mind, like just like the Super Bowl commercial. I hope you all heard Echo, so I'm not just talking to myself. Okay, we're finishing this. We're almost done. Finish him. We're almost done. Thus, while some of what goes on in a particular Housewives episode has some aspect of reality, in that Miss Shaw is playing a character called Jen Shaw, and not a totally fictional character who never existed. She is nonetheless playing a character who is molded by the requirements of being on the show. Any statements made in the context of playing that character on the show has been highly curated and edited to satisfy its dramatic requirements and do not have an indicia of reliability that would allow their admissibility under the trial rules of evidence. Oh my. Um I- oh my goodness. The defense reserves the right to supplement this opposition when and if the government seeks to use any clip or quote from the filming of Real Housewives of Salt Lake City at trial and address at the time any additional specific evidentiary objections. I would love to see the government object and say, I thought Kim Kardashian was going to be one of the lawyers. I thought Kim Kardashian was going to be one of the lawyers. I object. Where's defense counsel? We were promised on the show. We were promised on the show that Kim K was going to be one of the lawyers, where it is not materialized yet. The government should be precluded from introducing statements of alleged co-conspirators until the government establishes the scope of a single conspiracy. They say that the government has failed to establish the scope of the conspiracy it alleges against Ms. Shah in a way that Ms. Shah and the court can determine which individuals are co-conspirators. I think all the charged co-defendants. And I think that's what the court's going to say. And I think that they should have put that argument before the diatribe about the reality show clips, because by the time we get to the end of the reality show clips, I'm just done. I'm done. But what's interesting is that they talk about all of the other statements or all of the other cases. Statements of alleged co-conspirators are only admissible as exceptions to the hearsay rule when they're made by co-conspirators during the course and in furtherance of the conspiracy. In expounding on the charges against Ms. Shah, the government has repeatedly hearkened back to its prior case, U.S. versus Ketabachi. While the Ketabachi case involved telemarketing fraud spanning several states, 15 defendants and countless bad actors doing a variety of illegal things, Shah was not part of that case whatsoever, and yet the government stands by its position that the case against Ms. Shah are related to its Ketabachi case, the businesses, without explaining exactly how Ms. Shah fits into that case or who, in that case, if anyone, allegedly conspired with Ms. Shah in her indictment. Furthermore, Ms. Shah's own indictment charged 12 people across many states and years, most of whom are complete strangers to Ms. Shah. The defense contends that what the government has portrayed as a wide-ranging, state-skipping, decades-long telemarketing conspiracy may actually be a collection of parallel illegal schemes, often done with different means, different groups, and different actors, some of whom may overlap with one another. So they're trying to narrow down the conspiracy. Okay. It's a fair ask. I don't think it's going to win, but it's a fair ask. It's a good ask. They should have put that above the dissertation about the housewives, because I can't get into being like, okay, I can see your point, because I'm exhausted from 4 or 40 hours. I'm out after the Frankenbites. Frankenbites without consent are zombies. Y'all, what the fuck just happened? What just happened in that motion? So there's some of the motions in limine. Those are all of them for now. The government will be able to respond. The government will respond to Jen Shah's, and Jen Shah will respond to the government's. So we will see responses, and we will cover those. And we will cover the jury instructions when we get closer to trial in March, because there's no real point to cover it now. That we are now up to date on the Jen Shah. She is the last defendant standing. Everyone else has pled. Allegedly, she threatened Stuart Smith at some point. I can't wait to hear more about that. This is going to be a very interesting trial. And while this trial is going on, I will probably cover nothing else, because there is going to be so much going on, and I am still contemplating going to see it. I am going to say hello and goodbye real quick, because we're at like 3 hours. So hello and goodbye real quick. I know I missed some super chats. I'm going to try to grab those. And then I'm going to have to say goodnight. We're not going to get into a ton of questions. Thank you, Law Nerds, for being so amazing in the chat. Thank you for liking and subscribing and doing the YouTube-y things, and for having a little lighthearted, like, what the fuck is even happening in this motion? And they're relying on a book that says Frankenbites. Like, what is even happening? I loved all of it. It was chaotic. I understand the point. The point is, how do we rely on reality TV to know if what she said was actually what she said? And to that, I say, I said what I said, and who's going to check me? Boo. That's the response to that. But we'll see um, what the government responds with, because they have a chance to respond. I don't know if the government has the uncut footage. I don't know what we're going to see. I don't know if the government wants to use footage. The defense is trying to preempt some of that. So we will see what they decide to do, but that was hectic and I loved it. Cindy said, towards the NY trip for this case, I mean, we're going to have to figure it out. I've got, what do I have in early April? Well, we'll see if we'll see what happens. It is still my intention to make it to this case. My family's going to love that intention. They're going to be like, what is happening? It's like, no, I have to be there. Amy, hello. I emailed you an article at 8:45 Central Time tonight. Thank you for emailing it to me. I will try to take a peek. Amy, thank you for letting me know. And I appreciate it. It's been a really, really hectic week, but thank you for emailing it. Southern Nana said, love you. I'm in Housewives Heaven as well. Love this content and your priceless delivery. You crack me up. Thank you, Southern Nana. Miss Opinionated, I think I pulled that one up. Andy C said, book is bogus, no first person. I will, and again, how do they rely on this book with no authentication either in this motion? It's very interesting. I would love for the government's response to be, the show seemed pretty real when we arrested her on air. Seemed like an accurate description to us. They do have firsthand knowledge, which is pretty funny. Anastasia said, my fur baby son has a lymphoma removed Thursday. I've been binge watching you to help with my severe anxiety and depression with his surgery. Thank you, XO. Also sending lots of love to Peter Mon. Thank you for that. Fur baby stuff is very, very hard. I do not do well with fur baby stuff. It causes me lots of anxiety. I completely feel you. It is very hard. Tiho 1927, a friend is convinced that you used the name Desiree Lockwood when you were in acting school. I was never in acting school. Is my friend wrong? You've never mentioned I was never in acting school. I was never in acting school. But if I was, I would use the name Flint Lockwood, probably. Not Desiree. And I've never used the name Desiree, not even as an alias when I am intoxicated and don't want to give people my real name. Desiree is not my go-to, never. But I was never in acting school. Sorry. Ashley Vincent, catnip tip, make it rain on Fred and George, y'all. Make it rain, make it rain. Thank you so much, Ashley. Eric B said, question, does anyone know how long she's been Girardi been stealing clients' money? Did it start only after he married Erika? It doesn't seem to, based on the other older lawsuits. There are lawsuits going back quite a way. So it doesn't seem to just have started. Octonation, it's good to see you, friend. So have they been looked into how his ex-wives also benefited? I don't think they've gone back and looked into the ex-wives. One of his ex-wives is a creditor saying, hey, my $10,000 a month spousal support stopped. WTF, but no, I don't think they've looked into the ex-wives. El Marie said, I'm at the beginning of this video, but sending love from your Long Beach State family. Go Beach. Thank you. Oscar said, is there anything we can do to make them unseal it? No, with the Wendy Williams stuff, we cannot. The court has decided to seal it, and that's what they're going to do. I'm worried they will do the same thing they did to Brittany, but with Wendy, I am worried too. Avoma said, can Wendy share the information if she chooses to? Not the sealed documents. Nope. It is sealed. So no, she cannot leak the sealed documents. It would violate the court's sealing order. So no, she can share her opinions and things, but she can't share sealed stuff. So coffee buzz or what? Or what? Exactly. Or what? I love that in the Erika voice. That was a stunning moment of Housewives. I'm sure we'll have more of them this season. Cynthia said 2 things. Offer still stands to host a meetup with you in Manhattan. I mean, I'm here. If I get there, I'm here for it. 2, for the nerds, it is interesting to have a legal basis for the utter fiction of reality TV. I mean, it is. It's part of our research. We need to stay on top of case research. Jen has said there have been things that if I was a prosecutor, well, if I was the prosecutor on this case, I would want to use. So we will see. We will see. Awesome McVideos said, Emily, love your legal analysis to better understand the laws in the United States. You're welcome. Sometimes it seems chaotic, and I get it. You're such an awesome person to watch. I appreciate that. I appreciate it. You guys have been so great. Thank you for hanging with me tonight. I realize it's been almost 3 hours. I really, really don't intend for our shows to ever be 3 hours. I'm always like 2 hours. We're going to do 2 hours. And then fuckery pops off and we end up 3 hours in. I was going to be like, oh, we'll summarize it. And then there was a dissertation on how Housewives is filmed and I couldn't stop myself. I just couldn't. And it just is really nice to be with y'all. It's been a really, really rough week. And just falling down the rabbit hole of Frankenbites felt kind of cathartic. I'm going to be completely honest. Because, oh my, that was a journey that I was not prepared. I was not prepared for that journey. I was not mentally there, and I loved it. I loved like every single minute of it. So I will be scantily on social probably over the weekend and into next week, but I have every intention of being here Tuesday. So I will see you guys on Tuesday. We have lots more legal to talk about. So much has happened. So much has happened. So over on Patreon in the Law Nerds community and with the members here on YouTube, I'll be asking you guys about Tuesday. I will be covering the Rust wrongful death in next week's podcast with some of the breakdown video. I'll use some of the clips of that video of how they thought it happened, talk about the legality of that, using it in court, using accident reconstruction, which is essentially what it is, even though it was a shooting reconstruction, but using that kind of reconstruction to portray how they think it happened. It'll be very interesting to see. A huge thank you to the mods. As always, these are long rides. It's a lot to do, especially when there's like, 2,000-3,000 people chatting. And I appreciate the chat for always being such a conscientious place to have a conversation. We don't always agree with each other, which is the way it should be. We shouldn't all always agree with each other. Conversation is absolutely the most important part, and being able to understand where other people are coming from and have those conversations. I don't understand where this last part of this motion in limine is coming from, but I will try. So that's what's up. I will see you guys soon. Take care of yourselves. Hug your loved ones. Keep Peter in your thoughts. It is just, oh man, it is just. So stay hydrated, mind your business, hug your families. I appreciate all of you. I'm going to remember to roll the outro tonight. I keep forgetting. I keep like saying goodbye and then not doing it. So, thank you all for being here. I will talk to you soon. Thank you for being a Law Nerd. Cheers. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.